Good morning. Good morning. It's Wednesday. It's October 23rd. It is day 4 of the state of Florida versus Sarah Boone. We are now in the defense case because everything in this case has gone much faster than I anticipated. And as always, if you're watching in the replay crew, there will be timestamps down below. Just as a reminder, the defense's main defense in this case is a self-defense claim based on battered spouse syndrome, battered person syndrome. The defense keeps calling it battered women syndrome, but it is a domestic violence related self-defense. So if there are subject matters that you need to zoom past, they are all going to be timestamped in the replay, so you can zoom past that. But that's most of what the defense's case is. I expect that will be most of the testimony today, though probably more sanitized because it's going to be dealing with experts and law enforcement officers from past instances. So it's not going to be as detailed as Sarah Boone's own testimony yesterday. I am still surprised at how fast the cross-examination of Sarah Boone went. There were times last night when I was singing Yacht Rock with the Titans of Soft Rock Yacht Lake crew where I was going, I would have asked this. I would have asked this. Did yesterday's cross-examination of Sarah Boone live in my head? Yes. Is it still living in my head? Yes. Is there a lot I would have asked? In hindsight, yes. And we're going to talk about that throughout the day today and probably in other content as I continue to think about the cross. Look, I've not had this case for 4 years like the prosecutors. We are watching it in trial together as the unofficial jury of the internet. So we are just here observing, but I am, I'm curious how this will all unfold and how much I think the prosecution in their cross just let go of things and did not narrow things down. We'll see what their rebuttal case is. I'm trying to keep an open mind, but I don't love the way they did their cross. I think there were a lot of missed opportunities. We'll see what happens going forward. So with all of that, we are going to get into I think maybe the rest of the defense case. They were talking about travel issues with an expert. Maybe it'll be a short day. Who knows? So let me know where you're coming in from, what you're drinking. I have like water. I'm a cup gremlin today. Water. Lawnard cups. Yes, they are. Matte Black Lawnard cup. Oil Slick Lawnard cup. I have hot water with lemon because voice. And then I have a homemade cold brew. So yeah, we've fully cup gremlined this morning and I am living for it. So with all of that, I'm going to roll the intro. We're going to get to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
The court is doing my favorite thing.
Bring the jury.
And we're going to get right into it. We've left ourselves some zoom room. And if the experts speak in a more measured and slow pace, I will set us to 1.25 speed. The reason I did not do that with Sarah Boone's testimony, even when it was slow, is because I think demeanor is important. And we lose a lot of that on 1.25 with experts and law enforcement. Unless something's really happening, they're pretty used to testifying. So demeanor is not as important to me. So it just isn't necessarily something that is going to give us as much information. So let's roll. Let's just.
Our jury. Yes, Your Honor. Defense, do you recognize our jury?
Do you recognize our jury? Have they changed in the evening? Are they all here? Do we know who they are? Do we recognize them?
Welcome back to 12
now?
Alpha of the Orange County Courthouse. I hope you had a great evening.
Yes.
If you could, again, just by a show of hands,
could we not work like
break?
An extra hour?
All hands have been
raised.
Long
court days, Your Honor.
Members of the jury, at this point in time, the defense is going to continue with their evidence and testimony presentation. And I'm going to ask them to call their first witness at this time. Mr. Owens, you may proceed, sir.
I mean, it's technically their second witness. They called the defendant yesterday. They called, so this, I'm counting this as the defense second witness because they did call Sarah Boone yesterday. She was their first witness, but you know. And we're going to zoom as everybody's walking up to the stand. I'm going to try to condense today's court day. These have been such long freaking court days. Such long court days.
Good morning. You can be seated. And can you please state and spell your name for the record for me?
Yes, sir. Lona.
My name is Jessica, first name Jessica.
Sarah Boone testified, crossed, and was done yesterday.
First last name is Ramirez, Ramirez. Second last name is Delgado, Del.
No preliminary matters today other than a witness list from defense to the court that wasn't an email that they didn't
Ma'am, how are you
tell us.
employed?
I am a reserve deputy with the Orange County Sheriff's Office.
And how long have you been employed with the sheriff's?
7 years.
I'm going to see if I can gain this up a little bit. Give me 1 second.
25th of 2018, how were you employed at that time?
I was a full-time deputy sheriff for the agency.
That's better.
On that date, ma'am, did you have the occasion, due to your duties, to report or to go to 4748 Franks Lane, apartment number 3?
Yes, sir.
Do you recall what you were going there for, the purpose?
Yes, sir. I was a backup deputy for a call involving a male kicking a female in the face. So it
Sarah
came
does
out
not
as a
like the word
domestic
kicked.
call.
So they are bringing in deputies from the prior instances. Yes, they are allowed to bring in deputies who responded to the prior instances. Yes, Sarah Boone is done testifying. These are deputies who would have been called out when police were called for the prior domestic violence instances or incidents between the victim and the defendant. So these are going to be the responding officers, and I think there are several of them that take the stand in quick succession this morning. So
Was it another officer who also responded?
Yes, sir. He was the primary.
Ma'am, while you were there, did you have contact with Sarah Boone?
Yes, sir.
While having contact with Ms. Boone, were you able to observe any injuries
Yes, sir.
to the person?
Yes, sir. She had swelling and bruising in her right eye.
And ma'am, were you able to make contact with Mr. Jorge Torres?
Yes, sir.
Were you able to notice any?
this is all leading.
Yes, sir. He had red markings and some abrasions around his neck.
Some of it's background, but the
Ma'am,
prosecution's not
at a certain
objecting
point
like
in
yesterday,
time,
so
did
it's
you
not for me to
place
complain.
Ms. Boone under arrest?
I still
Yes,
might.
sir. I detained her and placed her in my vehicle.
Ma'am, at that time, do you recall or remember Ms. Boone?
I appreciate, and I think there are times when I criticize something, I'm going to criticize it on both sides. And when I appreciate something, I'm going to try to appreciate it on both sides as well. I appreciate that they're getting out ahead of the fact that Sarah Boone had been arrested. She talked about that in her testimony. She talked about it with the deputies when she was arrested. So I appreciate any time the attorneys are like, this is coming out either way. So let's go for it.
Asking you, why am I in trouble?
Yes, sir.
And without saying what you said, but did you respond to her?
Yes, sir.
After that, ma'am, do you remember Ms. Boone asking you why? Because I fucking fought back.
Yes, sir.
That was her testimony. That was her testimony yesterday.
Right, ma'am, one moment.
Yes, sir.
During the course of your investigation, you or the other
That was the end of direct examination. This deputy went to the scene, for the incident that Sarah Boone talked about yesterday, where she said she was stomped in the face. They say kicked in the face. I don't think it is a distinction that matters. It matters to the defendant. But this officer is like, yes, I rolled out. Yes, I saw injuries. Yes, I saw injuries to the victim. Yes, we arrested Sarah Boone, and now cross.
responding deputies spoke to Mr. Torres as well.
Yes, sir.
After concluding all of your investigation, which involved talking to both Mr. Torres and to Ms. Boone and making your observations of the two of them, did you all make final decisions about how to handle your investigation?
The other deputy, which at the time was Deputy Zito, was the one that made that determination.
Okay. But that's collectively what you all looked at was
She's like,
statements
wrong
from Ms.
deputy.
Boone and Mr. Torres, correct?
Yes, sir.
And your physical observations of both persons?
Yes.
And then whatever else you may have observed on scene?
Yes, sir.
And do you take into account people's demeanor when they are giving you statements when assessing their credibility?
Yep.
Sir.
No other questions?
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Yes.
All right, thank you.
That's it. All right, defense witness 2 is done. I'm going to zoom as they call witness number 3.
Defense, call your next witness.
At this time, the defense calls Deputy John Aldan.
Another deputy coming up to take the stand.
Sir, good morning. Can you state and spell your name for the record?
John
For everybody's-
Aldan, John.
For everybody's like, that was so fast. Yes, they need to ask them like 4 questions. That's the information that they need. That's it.
Alden.
All right, thank you, sir. You may be seated. Mr. Henderson, you may inquire.
Good morning, sir.
Morning.
Sir, how are you employed? How are you employed?
I'm employed with the Orange County Sheriff's Office as a corporal.
Back on August the 28th of 2019, how were you employed?
I was a deputy in the Uniform Patrol Division in Sector 2.
As a part of your job duties that day, did you have the occasion to respond to 4748 France Lane, number 3?
Yes.
What was the purpose?
There ended up being a battery call.
And, sir, were you the lead officer on this case?
Yes.
Were there any other backup officers there with you?
I believe so.
Sir, on that date, August the 28th of 2019, did you come in contact with Sarah Boone?
Yes.
Sir, on that date, did you observe any injuries on Sarah?
Did you come in contact with Sarah Boone? Yes. Do you see her here in court? Defense? Are we going to identify the defendant at all? Didn't ask the last witness either. Maybe no one cares. It's the strangest thing I've ever seen. But the defense is doing it too, so I guess they can't complain about the prosecution doing it.
I observed redness on the left side of her neck and what to be an old injury to her right eye.
Sir, on August 28th of 2019, did you come in contact with Jorge Torres?
Yes.
Remember this incident happened in
Did you
2020?
notice any injuries on Mr. Torres?
Yes. He had some redness on it by his left eye.
Sir, on that day, was Mr. Torres placed under arrest?
Yes.
Thank you. I have no further questions.
Any cross-examination?
Yes. Is it fair to say that Mr. Torres had quite a few marks on him?
From my report, I remember marking the left by redness by his left eye.
And did you have a body-worn camera activated when you responded to this call?
Oh, we're probably
I
going to see
believe
that.
so.
And so that would be the best evidence of both video and audio as to what occurred while you were on scene.
It would, especially since this happened 4 years or 5 years ago now.
And did Mr. Torres refuse to say what happened that day?
He did.
Based on the conclusion of your investigation, which involved talking to Ms. Boone and attempting to talk to Mr. Torres, as well as your visual observations of both them and the scene, is that how you all reach your conclusions?
Yes.
No other questions?
Any
right.
redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
That was
Okay.
witness 3.
Thank you, sir.
Thank you.
These are the prior instances of violence. Some are asking if both parties are
Yes.
injured,
Go ahead,
why
next
is
witness.
the injured party also arrested? That is not uncommon, that until they can determine what happened, both parties can be arrested, sometimes are arrested. So it really just depends on the circumstance and what happens. I imagine we will see some of those body cams because the prosecution asked about it, especially with that last instant in October 2019. Remember this? This death happened in February 2020, so close in time then, not as close in time now. I'm gonna zoom. And they're approaching. We're gonna zoom faster. So we can see those body cam coming in, and we may.
Judge, at this time, the defense calls Deputy Koepsell. Excuse me.
So Sarah testified yesterday that the incident with the really nasty black eye was the first time she had called the police regarding this. I think the thing we learned from yesterday, and everyone has known about this trial since the beginning, is that alcohol is a huge factor of this case. Courtney asked in the chat, is he texting? Yeah, the defense attorney is probably getting the rest of their witnesses ready today. Wouldn't they have to recall that deputy while playing the footage? No, not necessarily. They can call the, whoever keeps the records, the proper word for that is escaping me, but they can call the record keeper to be like, is this the body cam from this day? But they can recall them if they need to, and that's probably not going to be hard.
Good morning again. Could you state your full name and date of birth for the record? Or, I'm sorry, full name and spell it for us.
It's Chelsey Koepsell, Chellcy.
And the defense is recalled.
Last name is
Detective,
Koepsell.
Homicide Detective Koepsell.
Thank you. Counselor, you may inquire.
Is witness 4.
Good morning, ma'am.
Good morning.
In relation to this case, on February the 26th of 2020, did you have the occasion to interview Abraham Marino?
Yes, I did.
Was that interview recorded, ma'am?
Yes, it was.
You remember as part of that interview that Mr. Marino tell you that he had had contact with Sarah Boone on February the 24th of 2020?
Are you asking the night of the incident when police were called out?
Yes, the next morning.
That's
The day that we were called.
That you were called out.
Okay.
The 24th.
So yes, he did have
calling for
contact with
hearsay?
her, but it wasn't in the morning. It was while we were there.
While you were there?
Yes.
What time did you get there? That's probably what's going on.
I got there around 14:20 hours, which would be 2:20 in the afternoon.
Okay. So the afternoon on the 24th.
No, it was later.
when she
I
talked.
recall, I believe I was doing paperwork in my vehicle, so it would have been at some point during the investigation, but it wasn't, I didn't notice him until, I'm not sure if I noticed him until before or after Sarah was interviewed.
All right. But to his interview part, the interview, did he tell you in the interview that he had had contact with
Oh,
Ms.
this
Boone
is-
on that day?
Yes,
My brain is yacht rocked. This is the apartment manager. I wonder if this is testimony to impeach the apartment manager and what his testimony was from Friday, because the apartment manager said that he had spoken to Sarah Boone before she was arrested in this case. Okay, sorry, took me a minute.
he did.
Did he tell you at that
Cheers,
time
chat.
that Ms. Boone had made a statement to him?
Yes,
So
yes,
this
he
is
did.
for
Do
impeachment.
you remember
Maintenance,
what
sorry.
that statement was?
Maintenance manager?
I don't wish to quote what he stated, so I don't know the
Yeah,
exact
I'm not
verbiage.
gonna state
but he
that.
basically replayed what. I'm not sure if he replayed what exactly occurred that day, but I do know he mentioned something about she mentioned being dragged down the stairs a couple days prior.
Did he say to you during that interview that Sarah Boone told us that a couple of days ago they had gotten into a fight where he grabbed her by her hair
calling for
and
hearsay.
dragged her down the steps?
That's calling for hearsay.
I
We
would
have
assume that he's reading my report, and that does sound similar to what my report should say.
So this statement was given
it's here.
on the 27th.
it's hearsay, but I think he's trying to use it to impeach, but I don't remember the manager testifying to that at all, but there's no objection to it. I think it's objectionable, but I'm not sitting in court.
7th of February. I'm sorry, the 26th of February. Would you agree with that?
She's like,
Yes, I would.
Okay.
get it right.
The contact and the statement that Ms. Boone made to Mr. Moreno was on the 24th of February. Is that correct?
Repeat the question, I'm sorry.
When Mr. Moreno is saying that Ms. Boone came up to him and made this statement that we just talked about,
Yes,
that was on February the 24th. Is that correct?
that is correct.
So when she said a couple of days ago, that would have brought it back to February the 22nd. Is that correct?
Potentially, yes.
Moreno said Boone told him, hearsay, but the defendant's statement can come in, but through Moreno, but okay.
Ma'am, during that
That
interview
Boone
with
said
you,
that there
did
was a
Mr.
fight
Moreno
on the stairs.
ever indicate to you that when he had contact with Ms. Boone on the 24th, that Sarah Boone told him what happened was an accident?
What?
Did he say that Sarah Boone stated that she was teaching him a lesson and things got out of hand?
Her face said
and
what
that she
out
fell
loud?
asleep.
I don't recall the entirety of that being accurate. Yeah, I don't recall the entirety of what he just said being accurate.
Do you remember him saying that at all?
He did say that she had, I believe he said on the recording, passed out. So that's why, like, part of the statements might be accurate, but
Ma'am, would it refresh your memory if you were to see the recorded statement?
his recorded statement,
Yes.
transcription?
Yes.
Sure, yeah, great.
May I approach the witness?
You may.
She's like, it's on body cam. He said what he said on body cam. Like, whatever he said on body cam is what he said to me.
Ma'am, take your time. Read through that.
Okay.
There is some okay, some sass.
I don't recall all the statements that you asked, or the way you asked it, but
Ma'am.
Would it help if I repeat it?
It would help if it wasn't compound, is what she's saying. I don't remember all the statements the way you said it, the way you asked it. She's just like, can you not ask a compound question? And that it's too early. So I think they are trying to use this to impeach Moreno, saying that what he said on the stand is not what he said to law enforcement. He was directly asked about it on the stand. Did you tell law enforcement this? And he said, I told them something like that. So if the jury hasn't already forgotten Moreno's statement, this is what this is going to.
sure, yeah.
Okay.
You asked, like, you said multiple statements, so
She's like,
this
yeah.
was a, like, 11-minute interview.
Your question sucked. So this is
the
why I don't wear my
statement
hair
would
down. It
be-
always drives me crazy. So sorry, Chad.
Yeah.
It's going to be a day of this. I'm working on it.
Sarah Boone stated to Mr. Moreno that she was teaching him a lesson and things got out of hand and that she fell asleep. And I'm wanting to know if
Did you say, okay, I thought I heard you say passed out the first time. I'm not sure if you said passed out or fell asleep.
fell asleep.
Fell asleep, okay.
And what I'm asking is there any indication that he told you?
Chat, let me know in the chat. Do you think Sarah Boone told Mr. Moreno from her apartment management maintenance team that she was trying to teach George a lesson and then she passed out and or fell asleep? Because it sounds very similar to what she said multiple times in all of her other interviews, that she was going to be heard and make him hear her. So yeah, I think she said it. Whether it's 100% said this way or that way, just pull the fucking body cam. Why are we doing this?
You that statement on the date of
Because
that interview
that sounds
on the
exactly what
26th.
she would have said. And that was... That's exactly what she would have said.
Sorry, I'm trying to go to the part where we talked about that.
Yes, ma'am, take your time.
She's like, I'm going to need to because you ask compound questions. Compound question means there's multiple parts to it that can't be answered neatly. It's like, Emily, last night, did you go see the Titans of Yachtly Crew in Nashville, dance in new shoes, which is ill-advised, and drink White Claw? I can't say yes to that question. So there are too many parts, and not all of it's true. There was definitely no White Claw involved. So that's compound. But I did wear new shoes. Ill-advised, but they're so cute.
Okay,
And
so
I did go to
like
the
I
show.
had stated, there were certain things that I thought was accurate from your statement. He stated, I don't really, do I just read exactly what it says?
No,
do
you
need, like,
never do
the number
that.
next to it or anything?
Yes, I have no problem if you read it.
I do.
Okay, then she,
Approach.
Oh, finally. The prosecutor found an objection. So I got new docs. And I very much like them, but they're going to
Thank you.
Broken
You
in.
may continue, Mr. Henderson.
he described,
Hang on. Just wait for a question,
so
okay?
sorry.
It's okay.
yes, sorry.
Yeah, you can't just read it.
Ma'am,
The chat knows that. The chat's like, you can't just read it.
anywhere in that
I'll show you guys the
interview,
docs. I'll get a picture of the new
you
docs.
see reference to this statement that Sarah stated that she was
Her face.
teaching him a lesson and things got out of hand and that she fell asleep.
Compound.
No to the two parts, the first two parts of your question. I heard passed out the first time you asked me this question, and that's why I said that part of it was accurate, because he did say that she passed out in his statement. That was what Sarah told him.
Okay, did she say she was teaching him a lesson? Is that in there?
No,
And things got out of hand. Is that in there?
no, I don't recall that.
May I approach the witness?
Yes.
Okay, so her report does not reflect that statement. Fine.
And again, ma'am, this interview was on February the 26th of 2020. Is that correct?
Yes, it was.
Thank you. I have no further questions.
Any cross-examination?
Is there?
No other questions, Your Honor?
All right, thank you. Can
I
this
guess
witness
it's
be
not on the
released?
body cam.
Yes,
So,
Your Honor.
State?
Yes, Your Honor.
All right, thank you.
or there's no recording of the interview because it's a witness interview later. All right. Goldie asked mods, is there a Discord for EDB? No, we have a Lawnard Lounge in the app at lawnardlounge.com. So that is what we use in the app
Call the next witness.
because we have control of it and it's easy for us to use and we can modify it so it's not confusing. Next witness.
Dr. Brannon is here.
All right.
Making sure.
All right, sounds like their next witness is their doctor. He said, I'm going to check. Guess what I'm going to do? I'm going to zoom. Zoom, zoom. And a zoom, zoom. And they're going to approach, so I'm going to zoom, zoom some more. So.
Your Honor, at this time, the defense would call Dr. Michael Brannon.
There we go. Defense witness 5 is their doctor. This is their expert. Jen said, why is it so important to impeach the manager? Because the manager said that Sarah Boone said she was going to teach him a lesson and things got out of hand. So,
Doctor, good morning. Could you state and spell your name for
I mean,
the
that's
record
something
for us?
you would think law enforcement would put in there.
Brannon.
All right, thank you. Counselor, you may inquire.
Dr. Brannon, good morning.
Good morning.
Spry, having just traveled from Miami to Orlando,
Yes,
Is that not correct? Okay.
it was a good drive.
So the jury was waiting for him for a minute. So I imagine that's why they said, how was the drive? Because they're explaining, I don't know how far it is between Miami and Orlando, but they're giving the jury a little context for the fact that he drove in this morning from Miami. So I think that's why they're asking.
Would you please describe for the jury your
Yeah, I
background,
imagine it would be
training,
a
and
several-hour
experience,
drive, right?
Both in forensic psychology as well as battered women syndrome.
Sure. So I'm a psychologist, licensed in the state of Florida.
So forensic psych.
I have a bachelor's degree in psychology. That's from a university called Nova University. I also have a master's degree in psychology. I received that in 1980, also in psychology. And I received my doctoral degree in psychology after a year internship.
I don't even have to put him at
I worked
1.25.
with
He
severely
just does it
mentally ill
himself. Thanks,
individuals
sir.
in Hialeah, Florida.
He's like, I got you.
In 1988, I finished my degree requirements for my doctorate in psychology. And in 1990, I was licensed as a psychologist. I've been operating as a psychologist since then, since 1990. Originally, I started off doing the work that most people kind of think about when they think about psychologists, doing therapy, counseling with people, helping them through with their problems, things like that. In 1994, I began on a career almost quite accidentally as a forensic psychologist when I testified in my first case in front of a jury. And from that time on, I've been doing mostly forensic psychology. My practice very quickly changed from that time on. I'm currently the co-director of the Institute for Behavioral Sciences and the Law, and anywhere between 80 and 90% of all my work now is related to some legal or court-related matter in the ways in which mental health interfaces or impacts or helps to give opinions about various legal issues. I've taught rather extensively in the area of forensic psychology. I teach to mostly legal audiences, but oftentimes, too, I speak to groups of psychology students wanting to sit up here and do what I'm doing as well. Make long drives and come up here and talk to people about cases. I also currently on the staff, the adjunct faculty staff for the School of Psychiatry at Florida Atlantic University. I help to train their forensic psychiatrists, so not just psychologists, but psychiatrists in terms of doing this work as a psychologist or as a psychiatrist, a mental health professional who gives opinions in the courtroom.
And are you also required
He's just
to
like, I do
update
this a
your
lot.
educational background and knowledge as a forensic psychologist?
Yes, sir. So sure. So every 2 years, we're required to get 40 continuing education credits to maintain our license. And part of that is we have to, on a regular basis, update our work in domestic violence.
Ours also has
women's syndrome.
specifics.
So we have to take those courses. We're all required, whether you're a forensic
This
psychologist
curl
or
is
not, to
killing me
take
today.
that coursework. So as part of our requirements, we also have to take separate coursework in regards to domestic violence as a general term, or intimate partner violence. But along with that comes discussion as well with battered spouse, or what's oftentimes called battered person syndrome now.
Right.
And I apologize. I'm kind of bouncing around here, Doctor. I apologize
Because
again.
relationships are not just
Uninitiated,
spousal.
just exactly what do you mean by forensic psychology?
So forensic psychology is a division of psychology. Most people don't think about that as often when they think about psychologists. But forensic psychologists are individuals who have degrees in psychology who are working to help to answer questions that come up in the legal system. It could be in criminal cases like we're here for today, answering various criminal questions, giving opinions about those questions. Or it could be in other settings like family settings, divorce proceedings, or sometimes civil settings like personal injury. Someone's claiming some emotional damage or something has happened to them. So forensic psychology is really the way that we use the science of psychology to help give opinions about various legal matters.
Damage.
Now,
But also, I really love Stephen He. So there's that.
So the DSM it stands for Diagnostic and Statistical Manual. It's kind of our code book, if you will, to help us to know what the different symptoms are for different mental health disorders, whether it's major depression or schizophrenia or anxiety. So it gives us a code book of here's the criteria you have to meet in order to have that diagnosis. And then we're able to utilize that in terms of either treatment, so even insurance billing, but being able to inform patients too about what condition we think that they're suffering from. It's been updated many times over the years.
I
It
need a
started at
Stephen
just
Hughes sound
DSM,
drop on the
and now
soundboard,
it's at the
honestly.
Diagnostic and Statistical Manual 5th edition, text revised.
I might need
So we've
that.
gone through a lot of revisions over the years to try to fine tune in an empirical or scientific way what the elements are, if you will, of various mental health conditions.
Now, you've been asked to testify today in regards to battered women's syndrome. Is
Sorry, that's
battered
my
women's
ice.
syndrome identified or located within the DSM-5?
So it is not. It is not a diagnostic category in the DSM-5 or other coding books as well. There's others besides the DSM. That's just the most popular one. But it's not a formal diagnosis that it
Right,
is
not a
contained
diagnosis.
within that book, a classification manual that I just told you about.
But sir, are there muffins?
Field of forensic psychology,
The chat would like to know
however, is there a subcategory
if there
that
are
is
muffins.
located within the DSM-5 that experts would recognize as a DSM diagnosis?
Yes, sir.
And what is that, sir?
So that category would be in the trauma section of the DSM-5 TR. There's a whole category on trauma disorders, and it's most closely related to something that we call post-traumatic stress disorder. That isn't the only trauma disorder, but that's the one that what used to be called battered women's syndrome, now I refer to it as battered person syndrome.
He's trying
but
to update
all
the
of it
language
really
of
is
the
more connected to a
defense attorney.
trauma disorder like post-traumatic stress disorder.
Now, testify that you testify on criminal matters. Do you also testify? You indicated also on personal injury cases and emotional. That would be civil, correct?
Yes, sir.
Okay.
I wanted him to say an emotional damage
In
again.
your experience, you've testified as an expert, as a forensic psychologist. Have you testified for, and today you're testifying for the defense or were called by the defense. Do you also testify for the state of Florida or other states within this country?
Counsel,
Yes to both of those.
all of the other attorneys have been much more concise. It's like, have you been hired and called by both prosecution, defense, both plaintiff and defense? That's all.
Testified in other states. I also testify for both the prosecution,
lemon poppies, you know, my
state or
favorite.
government, depending if it's federal or if it's a state case, and also for the defense. So I really get appointments and hired by both sides.
About how many times have you testified?
Wow. At last count, it was
Wow.
about 1,500 times. It's
Okay,
over
that's a
that, way
lot.
over that now. That was from a few years ago. But I testify in a lot of different kinds of hearings and trials over the course of mostly in
lot.
Florida, but in other states as well.
Now, you're familiar with the fact that there is a special jury instruction that's been recognized by the Florida Supreme Court.
Approach.
The prosecution is not sleeping. They don't always object when I think they should, but again, that's just me sitting here as in my house. You can't testify, he can't give legal opinions. So the jury instruction is not within his purview. So, oh, my in-ears are pulling on my neck. I'm going to start going rock star and just having one in-ear hanging out at some point.
Doctor, you testified as to battered women's syndrome.
No.
Battered person syndrome.
Yes.
Are there other synonyms or similar?
Did you literally just come back from sidebar to ask him what that's synonymous with? Sir, we're already struggling.
Names for what you're describing, in particular battered spouse.
He uses them synonymously.
Well, we talk about it in terms of trauma disorders like post-traumatic stress disorder, but the way when it's applied to the legal system, it's called battered wife, or that was the original terminology for it, battered wife syndrome or battered person syndrome. So really depends on your setting. So in this setting, we oftentimes talk about this particular condition that I've been asked to talk about today, is really referred to as battered spouse syndrome.
And have you been asked to give your opinion as a legal expert and on battered spouse syndrome?
Yes, sir.
How frequently have you been asked to do that?
I've been involved in about 100 cases of just that alone. I've been involved in some sort of testimony about 50 times.
And you indicated that you testified for the state, you testified for the defense, you testified in state cases, federal cases. Could you break down on a percentage basis the number of times you testified for the state versus testifying for the defense?
It's really close in terms of the last time we looked at it, it was about 50-50. On most cases, like for instance, if there's a case that involves battered spouse, potentially battered spouse or battered wife syndrome, I'm usually called by the defense first because they raise the issue. If you're called by the prosecution, whether it be federal or state, what oftentimes happens is it's in response to a defense expert that's been called. So do I agree or disagree with that other expert? So I'm usually, the call usually comes first from the defense, but in terms of who I'm hired by, it's pretty even.
In this case, the battered person is being used to explain the mindset of the defendant and kind of change the lens of how we see self-defense. So self-defense is based on what a reasonable person would do, and there is a need to give more information to that lens when somebody is dealing with trauma, because their lens is different when they are responding from having trauma versus somebody responding who doesn't have the same or similar type of trauma. So they're trying to help the jury shift that lens that they're looking through that determination of self-defense with. That is what this expert is for, to help explain what that lens is and explain behaviors, explain why someone might see something as a life-threatening situation when maybe others would not. So that's the purpose of this witness, and we will see how it goes. But that's what he's here to do. So when he's saying in battered person cases, the defense contacts me, right, because this is a part of a self-defense defense.
It's about 50-50.
No.
Hopefully that
This time,
helps.
Your Honor, I will proffer the witness as an expert in the field of forensic psychology.
Yes, approach.
Objection, may we approach? Okay. So they asked to proffer him as an expert. The prosecution objected.
Objection
And they,
is still sustained. Mr. Beck, you may continue.
the objection is sustained to him being proffered as an expert? Oh. I wasn't expecting that.
Has battered spouse syndrome been accepted, to your knowledge, in the Florida court system?
Yes, sir.
Sustained.
So I'm wondering if the prosecution is objecting, because they did it at sidebar, to the fact that they have not clarified enough that battered person is in fact a syndrome, what it is, because he's clearly an expert. I think this is going to him not defining, because they offered him as an expert in battered person. He might have said battered spouse. So,
Can you describe the classic system or systemology? Where
he can't give an opinion until he's qualified.
Might necessarily suffer and then exhibit symptoms of battered women syndrome?
Yes. So battered spouse syndrome is a woman, usually a woman's response. Doesn't have to be, but that's a classic historical research went into how women respond in situations in which there's intimate partner violence, when they've been the victim of violence. Now we know, of course, in other kinds of relationships, men can be a victim of it as well, or whether it's a heterosexual or homosexual relationship, that both men and women can be victims. But we still know the majority of those individuals that are diagnosed with that condition or given that condition, classified with that condition, are women.
Bless you.
We do know that it's a reaction, a strategy that's developed by the person who's being abused to someone who's abusing them in an intimate partner situation. And essentially what they're doing is they've made a determination that they can't effectively escape from the abuse. They can't just leave for some reason. They feel in danger, or they've been threatened if they leave that something bad will happen to them. So it's a cognitive or thinking strategy on the part of the person being abused that I have to develop some coping skills or ways of protecting myself, or maybe even loved ones as well, from some form of imminent violence or danger or lethality. Something bad will happen to me if I don't develop a way of handling this abuse, this constant abuse that's coming towards me. So the battered wife syndrome is really a way of thinking. It's a psychological change that happens with a victim in terms of the way they cope and strategize to stay safe for themselves and other loved ones as well, oftentimes.
I'm going to ask a really silly question, if I may, Doctor.
So I see a number of you in the chat saying he didn't interview Sarah. I don't know if he did or didn't. I guess we'll find out. But you can have an expert come in to explain what a thing is, even if he did not interview the defendant to be an expert in the thing and explain the thing. Like you have tech experts come in. I mean, generally they also look at the tech, but we will see.
I don't know if you've noticed a bruise across the bridge of my nose this morning.
I did see that when I come in. Yes, sir.
Okay. This weekend, hypothetically, if an individual was digging around
Lots
in the
of
garbage, the lid fell
prosecutorial
down and
objections.
cut his nose, the bridge of his nose wide open, would you, as a forensic psychologist, anticipate, or a psychologist in general, anticipate that there might be a physical or a psychological reaction or response to that degree of trauma?
So I don't know if it would be trauma or not. It could be, depending on the degree of the injury and the pain and things like that. But certainly you'd view that garbage can differently as you approached it. So it changes your psychology or the way that you look at that particular situation or that particular object. So by viewing it differently, you may engage in different behaviors. You may approach it differently. You may have somebody else approach it. You may approach it with both hands up. So it changes your behavior and your thinking about that garbage can.
Does that also apply to
Sir?
relationships?
So it certainly can.
Did the garbage can hurt you?
No two people always react the same way to every situation. Trauma, one person's trauma is not a trauma to another person. But for people who do develop battered spouse syndrome, they do begin to change the way they view the person who's abusing them and what they have to do in order to maintain either their life or their safety, their physical safety in terms of their behavior and interactions with that person.
Now, is there a specific set of criteria that a psychologist, forensic psychologist, would necessarily rely upon in attempting to make a diagnosis or an assessment of battered women's syndrome?
Yes, sir.
And what are those criteria?
Well, you'd want to see one if some type of abuse has occurred. That abuse can be physical, it can be sexual, it can be emotional, or it can just be the threat of abuse or bad things that's going to happen to you. So there has to be something bad that's happened or that's threatened to be happening over a period of time. So abuse has to be present in order for this to be underway. Without abuse, there's no battered wife syndrome. But that's not enough.
Oh, now
there also has to be what's called coercive control. Coercive control is really keeping the person's social interactions, overseen on a regular basis, controlling money, controlling preferences, even TV preferences, sometimes
Music
social
preferences.
media, looking at social media that the person is accessing or looking at, who they're talking to on Facebook, who they're texting. So it's a combination of abuse and coercive control that results in a person feeling victimized, but that's still not enough. That person then has to feel like they can't escape from that. They've either been told, if you leave me, you're going to die, or a family member is going to be harmed.
Or the dogs.
Your children, your mother, whatever it might be. And as a result of that, they develop strategies to cope with that, acquiescing, pleasing, doing anything they're asked to do, demeaning themselves, allowing themselves to be controlled. All of the things that would fend off, if you will, some abuse or attack or threat to them or someone who surrounds them. So those would be the components that you would need to have, and that dance continues to go on usually repeatedly throughout the course of that relationship.
So I think what you're describing is, in a sense, a subjective nature to the syndrome that's being described.
It's both objective and subjective. So objective in terms of the facts, like what's really happening. A person's being abused, they're being told certain things, there's control over them. But then the subjective part is the person's interpretation of that, their perception of that. So there's really both going on, and they have to kind of work together in order for this syndrome to be formalized and properly diagnosed.
You indicated that there sometimes may be some defense mechanisms that are, or strategies that are devised by the battered individual, the abused individual.
Yes, sir.
In your experience and your training, do controlled substances, alcohol, drugs, frequently appear in your analysis or assessment?
Yes, and the way they appear is they can appear either from the abuser or the abused or both. What can happen from the abuser standpoint is they may only be abusive, or the abuse may become worse if they abuse substances. From the abused standpoint, it may be self-medication. It may be a way of coping with the anxiety that there's going to be something bad that potentially could happen to them or somebody else. It's kind of a way of dealing with walking on the eggshells. So if I use substances, that can deaden the pain, if you will, for me, or help me to forget about it. So it's oftentimes, not always, but oftentimes part of either the abuser's behavior or the abused behavior.
Do they, in your experience, do they, on occasion, actually defend the individual that is abusing them?
That's a very frequent part of this syndrome. Not always, but it's very frequent. It's why interviewing them becomes difficult sometimes, because they're used to explaining away their behavior, the abuser's behavior, my black eye, my missing tooth, his screaming and yelling in the background while I'm talking to mom on the phone. So they're used to making excuses for it. It's part of the coping strategy, trying to explain away this behavior. He's had a bad day. She's, really upset about something else that's going on. She's really never like this at any other time. So defending that person is oftentimes a part of the battered spouse syndrome, and getting the person who's been abused to get them to stop defending them so they can talk about the actual abuse becomes a challenge.
Now, the DSM makes reference on occasion to rule outs, I assume for the diagnosis that's being applied.
I mean, it's not a diagnosis.
A rule out in our parlance says that we should consider these things before we look at other diagnoses. So, for instance, if we're going to consider schizophrenia, we should rule out substance abuse first, because oftentimes some drugs can create hallucinations and delusions and psychotic symptoms. So there's always rule outs, just like there are for medical conditions. So look for this before you consider this, is really what a rule out is.
Are there specific rule outs for battered women syndrome or PTSD?
Sure. So there's rule outs for everything, because you're considering a number of different conditions before you make a differential diagnosis, or you pick that's the one that I think best fits this person. So yes, there's rule outs for both of those.
For my sake, what is a differential diagnosis?
That's how you decide which one. It's whether it's your medical doctor, your psychologist, whoever. It's how they pick the right diagnosis. So you're going through kind of a card catalog in your head, and you're saying, all right, there's symptoms of this, but that's also consistent with symptoms of that. So is it schizophrenia? Is it bipolar disorder? Now I have to ask more questions. It's a decision tree. And that decision tree helps you to inform the person and either make a diagnosis in a legal setting or help to treat them clinically.
Now, if the individual, the psychologist who's doing the evaluation, identifies the presence of certain rule outs, what is their response professionally to those rule outs in establishing or assessing the patient?
Well, what are the rule outs
You
here,
have to go
though?
down a decision tree. And we all kind of do decision trees in our mind every day about what we should do or shouldn't do in certain situations. It happens automatically. It's more structured when you're doing it professionally. So if you have a concern about substances, then you would kind of take that track and you'd have to ask a lot of questions in that area. So you'd want to know what kind of substances, how often are they using those substances, what kind of effect have those substances had on them before. I just picked one of many possible rule outs there. But every one of them you'd have to explore or ask additional questions, because of course you don't want to come up with a wrong diagnosis, because in a legal setting that leads you to a bad opinion, in a clinical setting it leads to bad treatment.
Now, I want to go back just a second. We talked about the subjective nature of the abused individual's understanding of what's happening. Does this subjective, or does the experience that they have suffered result in, on occasion, their experiencing or their anticipating or assuming or imagining a threat that others may not?
Yes, sir.
Yes.
And they're going to approach about that. He's trying to get at the lens that somebody who has suffered abuse might see things, or particularly threats, through. That's the question he's trying to get to. The prosecution objected. They are back up at sidebar. No, this doctor has not been qualified as an expert. So at this point, he's not going to be able to give an opinion on this case. He is telling the jury about what battered person is, but he's not going to be rendering an opinion. So let me zoom through this sidebar.
Doctor, from what you described this morning, I think we're talking about a complex and sophisticated process for assessing and diagnosing PTSD, battered women.
It's not a diagnosis.
Is that a fair statement?
Yes, sir.
And in this instance, this particular matter regarding the state versus Sarah Boone, were you approached about the possibility of doing an assessment as to Sarah Boone?
Approach.
Again. What is going on? I'm going to need these sidebars. Because that's a lot. That's a lot of interruption. I'm not surprised the witness is looking at the jury like, ah. That's a lot of interruption in expert testimony. And I see you in the chat saying PTSD is a diagnosis. It is, but battered person is not. And I do not think Sarah has been diagnosed that we will see in this case. It's a lot of sidebar.
Same.
Huh. So a number of you have asked which defense attorney is questioning the one in the white shirt that's walking back to the podium now, who is doing the experts. There is quite a thorough and full defense team here. Prosecution made a motion yesterday regarding whether there was any conflict about how Sarah Boone is not paying this because she's been declared indigent, meaning she can't afford it. I think we know that from her testimony. So these attorneys, as the judge said, parachuted in, and there is a full fleet of attorneys on this team.
When you are retained to do an evaluation in these matters, what is your practice in regards to the assessment proceedings, the assessment?
So what's the assessment procedure?
Well, I'd first want to know what type of an assessment that it is, because there's different methods of approach that you'd use to analyze and be able to give an opinion on whatever question's being asked of you. So the very first goal for me as a forensic psychologist is to isolate what the question is. So what are they asking me
Good
to
questions
do?
get better
Because I want to
answers.
know, A, can I do that? Am I qualified to do that, or should I refer that to somebody else? Or B, is that something I'm going to have enough time to do and enough resources to do? Then the next thing I would do is start asking questions about specifically what you already have or what can you get to help me answer this question. So right away, I'd start to find out what's available. As forensic psychologists, we're supposed to do comprehensive evaluations of whatever the legal issue or question is, and it's supposed to rely on multiple sources of information. So depending again upon the question, I'm trying to then define early on what are those multiple pieces of information I'm going to need to help to try to give an opinion and an educated opinion about that matter.
Have you done an assessment in this particular case?
No, sir.
Okay.
Can you tell us very briefly whether that was your decision?
Objection, relevance.
Okay, that's fine. That's fine. Move on.
Objection sustained.
In your experience, doctor,
Thank you very much.
Huh.
can battered women syndrome rear its ugly head? For instance, when there are threats to other members of the family, two-legged or four?
So yes, that's very common, that it's not just the person. It increases the terror from someone who's doing the abuse to mention other family members that they might also suffer
He's
abuse.
trying to talk about pets.
So whether it's emotional or physical, those type of things are very common.
He
Not
wants to
always,
talk
but
about the
it's very
dogs.
common in the course of domestic violence cases or intimate partner violence.
He wants you to talk about the dogs. He wants you to talk about the
And
dogs.
that fear that's developed by the abused individual may exist contemporaneously with other issues, alcoholism, schizophrenia, and the like. Is that correct?
Yes, sir. They can all be combined together, and certainly that increases if there's other family members that are threatened or live in the same home or close by. That can increase the terror, and the purpose of that is to increase control, to make sure the abuser has more control over the person who's being abused.
1 second, Your Honor. May I?
Yes, sir.
They didn't get as much out of him as I thought they would. He was not qualified as an expert in this case. He did not evaluate the defendant. He seems to be here as a general expert to give an overview of what battered person syndrome is, and I don't know if he's done a ton of that.
Doing an assessment, doctor.
Or well.
Do you look at outside materials?
Yes, sir, always.
And what kind of outside materials do you necessarily review in order to make this assessment?
Specifically to battered woman syndrome?
Yes, sir. Yes, sir.
So specific to this, you'd want to look at a lot of different sources of information because you're trying to, A, make a diagnosis if there's a trauma-related disorder, but you're also trying to figure out if there's the other elements necessary to make the diagnosis as well, like abuse that's been chronic over a period of time, and that the person feels they can't leave that situation, and if other people have been threatened. So you'd want to know things like not only what the facts are of the particular incident, usually some crime that's been committed, but you'd want to know the history of those behaviors. Has anyone else seen those? Are there people you can talk to? You know, friends, neighbors, bosses, anybody who's seen or heard of this abuse before? Have there been medical visits where the person has actually been damaged and shown up, made some other excuse, they slipped or fell or whatever it might be? You'd want to do psychological testing as a forensic psychologist because we have very good tests that help us to determine whether someone's suffering from a trauma-based disorder
That's
or not.
extensive.
You'd want to know if the person who'd been accused of the crime for this type of evaluation made any statements to the police. If they did, you'd want to hear that statement. Or has there been a 911 call or calls? If that's happened, you'd want to hear that too. So any evidence you could collect, and these are some of those questions I was talking to you about before, you'd want to ask the person who's trying to hire you in the beginning, well, tell me what you have. Because you'd want to see whether or not you're going to be able to make this analysis or not. So it's not good enough just to talk to the person, because that's just one form of information. It's almost like being a behavioral detective, if you will, as a forensic psychologist.
Exactly what it's
trying
like.
to get as much evidence wrapping around our interview with the person as possible to be able to guide our questions, but inform us and see whether there's what we call convergent validity. It's a fancy way of saying, does everything agree with each other? Does everything connect in a way that
I like the
it
way
all
he
sort of
testifies.
makes sense? Or are these strange, conflicting pieces of evidence that we need to explain away, or it just doesn't fit the criteria? So it's a rather comprehensive and complex evaluation that has to be conducted to come up with this. And the final piece I'd say about it is that because oftentimes the abused person is defending still the person that they've oftentimes committed a crime against, it takes a bit of time to get to where you need to go. With all victims of trauma, whether you're talking about situations where you're doing therapy or you're doing an analysis in this type of setting, a criminal setting, it usually takes some time to break through that and get them to trust you to talk about the trauma, but to stop defending the person and talk about the abuse and how they felt about the abuse. Your goal, if you will, is to be able to see what's happening in that situation through the abused person's eyes. If you look at it through your eyes, often it doesn't seem to make sense.
And that's the
But
point
if you
of
look
this
at it
witness.
through their eyes, if it meets the criteria for a battered spouse, then you can better understand their world and what they're dealing with.
Right. That's the
Real
point.
briefly, some of the things that you are evaluating when you examine, particularly the individual themselves, you're looking for anxiety and or fear,
Yes.
low self-esteem.
Yes.
Are you looking for depression?
Yes.
Are you looking for any form of social or interpersonal withdrawal?
Withdrawal, especially if it's forced withdrawal, controlled withdrawal, if there's consequences to socializing with my family,
withdrawal.
my friends, calling them on the phone, texting them. So especially in that context.
Stockholm Syndrome.
Sure, that can be part of it.
And what is Stockholm Syndrome, real briefly?
So it's really adapting to someone who's captive or taking over a person, controlling their life, sort of adapting to that situation. The famous model of that would be many, many decades ago, a woman called Patty Hearst, who was kidnapped. But it's taking on the beliefs and taking on an acceptance,
I didn't expect
if you will,
Patty
of a
Hearst to
kind of
enter
a captive
the conversation in
And
this
these
trial.
situations with women who have been abused who meet the criteria
At all.
for battered spouse syndrome, they oftentimes adapt, defend, and take on in an acquiescent way that this is okay and I'm part of this situation as opposed to opposed to the situation.
Will this syndrome exhibit itself in physical attributes?
It can, at times, even physical illness at times.
Inability to sleep, inability to keep food down, and those type of things.
Sure.
An ability to
Yes, sir.
sleep does not necessarily sound like
That
your client, though,
individual
counsel.
potentially experience hypervigilance.
Well, that's a large part of it.
That
Any
needs to be
trauma-based
explained.
disorder is hypervigilance. What changes when you've been traumatized, any kind of trauma, not
Oh,
just
good.
abuse.
He's just explaining it.
But what changes is your perception of danger. So whether it's the lid of the garbage can hitting on your nose, or whether it's someone being abusive towards you, those situations change your perception of danger. So you no longer see that object or that person in the same way. You have a foreboding sense of danger could occur. So other people may not perceive it with that person. He's so nice at work, or he's nice in these other settings, or he's so great on the softball field, but at home he's different. So that person who's being abused, their perception changes.
I need him to explain that.
It could include denial, and oftentimes
More.
that's part of the explanation. The defensiveness of that person is the denial of how bad things are that are going on.
I think the defense should have asked more about that, about hypervigilance. I suspect there's a reason that they're not talking about hypervigilance more, but
Any
I
cross-examination?
am surprised they're not asking more about that.
Good morning.
So I see a number of you asking as we get into cross-examination about why he is not an expert. It's not that he is not an expert. It's not that he is not a qualified human. It's he is not being qualified as an expert in this case to give an opinion on this case, meaning he can't give an opinion that Sarah Boone was or was not dealing with or suffering from battered spouse, that this is what's going on with her, because he did not evaluate her. So he is qualified to explain the testing, psychology, explain the syndrome and explain those things, but he is not qualified to give a hypothetical about Sarah Boone. So he is an expert. He's clearly qualified, but because he didn't interview her in this case, they are not allowing him to opine as to her or this case. He's here to kind of give an overview explainer of what all this stuff is. So hopefully that helps.
Good to see you again.
So there is a subjective component.
So now we're on cross.
What I understand you're saying, correct?
Always. Yes, sir.
And so hypothetically, a couple could be in a 3.5-year relationship with physical violence, emotional violence, even sexual violence.
I know he's going to ask hypos. There going to be an
Either or
objection?
both of those partners may or may not believe that is a traumatic experience for him or herself, correct?
Yes, sir. People mistake the stimulus about what happens as the trauma. The trauma is really the reaction to it. So bad things that happen, people don't always react in the same way to them. So yes, sir, that's correct.
So for instance, a homicide detective or a homicide prosecutor may go out to a scene and see a freshly dead body, and their perception of that environmental stimulus may be very different from somebody who works at Dunkin' Donuts and just gives us muffins in the morning coming across the dead body.
Jesus Christ.
Yes, sir. That homicide detective.
Who at the prosecution table is watching the stream? I need to know. Somebody tell me who's watching the stream. Who is watching the stream? How are we getting to muffins? I think that's bingo. I think that's bingo. Bingo. I think that's how? How did muffins enter the chat in this trial? Not only muffins, we've got muffins from Virginia and Duncan from Canton. And day four is bingo. Day 4 is bingo. The muffin. I'll take the muffins with the forensic psychologist because that is required. It's not just muffins. Muffins plus forensic psych. Are you? And now I want muffins.
Detective or a homicide prosecutor may go out to a scene and see a freshly dead body, and their perception of that environmental stimulus may be very different from somebody who works at Dunkin' Donuts and just gives us muffins in the morning coming across a dead body. Is that fair?
Also, When you think of Dunkin' Donuts, is muffins the first thing you think of? This is such an oddly specific reference.
Yes, sir. That homicide detective may be able to go eat lunch right after it, and the other person who works at the donut restaurant may not be able to eat for a couple of days as a result. So, yes, perception is a big part of how trauma occurs.
And I understand your answers today, and I'm not saying that they were different.
I'm kind of
but
just...
I understand you to say that it's very important to do a comprehensive evaluation.
Does Dunkin'
to get
Donut
the full
have
picture
muffins?
of what is going on in
It's
the
so
perceived,
specific.
battered spouse mind, correct?
Yes.
Oh my goodness. All right. They do have muffins at Dunkin' Donuts. See, I go to Dunkin' Donuts not often. I grew up in Southern California. We are not as Dunkin'-y as other places. We had a lot of local, like family-run donut shops, which is what I grew up with. Love, love, love. There aren't as many of those elsewhere in the country. Southern California, plenty of family-run local donut shops. But this is the one time a year I do Dunkin' because they have the pumpkin spice donuts. I also like cake donuts. So now is the time of year that I Dunkin'. I didn't even know they had muffins because I literally go once a year and I'm like, we out of pumpkin spice yet? No? Good, I'm in. But when pumpkin spice is gone, I'm out. So this trial has just been but muffins with the forensic psych on the stand is wild to me. They're back at sidebar trying to narrow down what this witness can and cannot testify about.
So, we've been talking about the importance of doing a comprehensive evaluation with as many collateral.
If I'm the prosecutor, I'm trying to use this witness to point out all the things whatever the other witness didn't do. And all the reasons the other witness isn't a great witness. I'm using this witness to my own advantage.
Sources as one could possibly have when making an assessment about the battered spouse syndrome, correct?
Yes, sir. It's a relevant piece of information. Yes, sir.
And would you agree that obviously the person who is accused of committing a crime, there are credibility issues that you do need to care for when relying upon that person's history provided about the events leading to that and the past events describing the relationship with the intimate partner?
Yes, sir. In every forensic evaluation, that's the case.
Is this particularly important if there's a comorbidity with an alcohol abuse disorder?
Yes.
And can you tell the jury what alcohol abuse disorder means in the DSM-5 TR?
Sure. It's the biggest part of it is it's not just the use of alcohol, it's impairment that happens as a result. So it's the excessive use of alcohol, but that could mean something different, just like the excessive use of marijuana might mean. But it's the use of alcohol to the degree that it impairs or infects a person's life.
Why is marijuana
and with that
catching
may come a lot of
strays?
other things like deceitfulness or aggression or unreliability, sleep or somatic problems, difficulties. So, but the important thing to remember there is that it's the use of a substance that impairs or affects a person's life.
And if there is alcohol involved in the histories being given about either the event in question or any preceding events, must the evaluator take that into account when evaluating the memories and perceptions of the person giving them that history?
Yes, so in introducing that new topic about memory, we know that substances can interfere and impair memory. So as a result of that, you want to know what they were using, how close it was. If you're talking about a particular event, like a crime, you'd want to know if there was substance usage, and if so, what the person's memory functioning was, and does that match up with other sources of information about what those events were.
Are you familiar with the narcissistic personality disorder?
Yes, sir, of course.
Is that something recognized in the DSM?
Not surprised that came up.
TR?
Yes, sir.
And can you tell us whether or not a person who is giving a history, whether it's the patient/client or whatnot, has traits, perhaps not a diagnosis, but even just traits of the narcissistic
Well, we know
personality
there's not a
disorder?
diagnosis then, don't
Is
we?
that something the evaluator should account for in evaluating the credibility of the history given?
Yes.
And why is that?
Well, because all forms of disorders or conditions or just traits may lead to inaccurate information, either not purposely or purposely. They may be deceptive. So certain personality disorders or traits can lead to deception or inappropriate or inaccurate information. That's why you need more than one source of information. Does what this person is saying to me check out with other sources of
More than one
information?
source of
I don't mean to
information.
quiz you on it, but can you tell us some of the criteria for the narcissistic personality disorder?
The prosecutor's
Again,
not
yes,
letting
sir.
that go.
So it is a grandiose sense of self-worth. It's the consideration of yourself.
excuse me, sir, I excel at everything. Fuck off. I was being sarcastic.
Over anybody else. It's kind of operating in your own world, so it's an inflated sense of who you are. It's a misperception of how important you are to other people and your meaning to other people. It's a sense of specialness, that you stand out from other people in terms of special skill or skills, and that other people, if they don't recognize that, they should recognize that. So the biggest heading there is an inflated sense of self-esteem and grandiosity.
Are you familiar with an adjustment disorder diagnosis?
Yes, sir.
So when we're talking about he is not diagnosing Sarah Boone. He is allowing the jury to hear the words and determine for themselves if these are things that should have been considered. So for all of you that sat here and were like, there are times that her testimony was giving murder, I understand. So it's a very, at this point, useful cross-examination, having him educate the jury so they can make their own determination and they can draw whatever conclusions they're going to draw from his information. So it's just placing the educators or placing the education out for the jury so they can make their own determination.
And is that in the DSM-5 TR?
Yes, sir. Correct.
Can you tell us about that?
Adjustment disorder is a person's reaction, and it could be emotional, it can be behavioral, or it can be both, to a situation that occurs. You broke up with your boyfriend or girlfriend, so you're upset about that. And so as a result, you're tearful, you're anxious or nervous or worried about what may happen to you as a result of breaking up with them, or you behaviorally may start not going to work, or get into more arguments or fights with your children as a result. So it's a temporary reaction to a stressful situation that occurs in some individuals.
And hypothetically, if a person who is giving a history for criteria of diagnosis, let me strike that. If somebody is giving a history and that is being used to come to an evaluation conclusion of battered spouse syndrome, if that person has been diagnosed with adjustment disorder predating the traumatic relationship, is that something the evaluator should take into account?
You'd want to know any prior diagnosis because it may not necessarily be exclusionary, but it could. So adjustment disorder is a temporary reaction. You're upset in a temporary period, and most of them just go away on their own. Whereas something else like a traumatic stress disorder is long-term. It's something that a person's stuck with for a period of time that usually doesn't just go away on its own. So yes, you'd want to know that for that term I used before, that differential diagnosis. You'd want to know those things.
You need to know all of that stuff.
Compare and contrast them and hold them up against each other.
Now, hypothetically, if somebody says things like, I'm the best thing that has ever happened to you, and
I excel at everything. Go to I excel at everything. If you don't say at one point, I excel at everything, counsel, Emily, what are you going to do? I'm going to yell at, the chat. The chat and I are going to yell.
I'm the best you'll ever do. Are those indications of the narcissistic personality disorder?
Well, they could be. You wouldn't want just that alone. You'd want to see if that was happening in other settings. Is that happening on the job, with friends, with family members? Is it showing up on psychological testing? But certainly that would be a red flag. You'd go, I want to pay more attention to that. I want to investigate that further.
And is it important when evaluating
Fred
trauma-based disorders?
What's going on, boys? Why do you look guilty?
To do that rule out on alcohol or drug use?
Certainly you'd want to do that. It's not usually disguised as a trauma-based disorder. Alcohol and trauma aren't usually rule-outs for each other, but it could exacerbate a condition. It could make you diagnose a trauma condition when it's just an adjustment disorder. I say just, I don't mean to minimize it, but it's not as serious as a trauma-based disorder.
Is it important to consider whether the
good testimony for the state.
the abused behave differently in the absence of alcohol or drugs?
Yes.
And why is that?
Well, because you're trying to analyze a psychological condition. If, as a result of drug or alcohol abuse, their behavior changes or their perceptions change, that's not a psychological condition, that's a substance abuse disorder. So that's why you'd want to know that. So if their condition remains the same, maybe it's a little worse when they're using drugs or alcohol, but it's the same perception of threat or danger, then you're going to diagnose a trauma-based disorder. If not, then you're going to diagnose a substance abuse disorder. You can have both, but you'd want to rule one out as opposed to the other.
And are you familiar with the classic three-step cycle of battered spouse syndrome or domestic violence?
Yes, sir, I
Can
am.
you explain that to the jury?
Sure. So there's a cycle of violence that was first developed by a woman in the 70s called Lenore Walker, Dr. Lenore
This is
Walker.
a helpful cross for the
She's usually
state.
credited with developing the whole theory of battered spouse syndrome.
At the end of this witness, I'm going to ask you if you think this witness ends up being better for the state or the defense.
And in the classic model, which we know oftentimes happens, not every time, but in the classic model, there's a period of tension buildup where things are happening, little arguments are happening, there's bickering back and forth, there may be some threats or some loud voices back and forth, but it's all things that are leading up to a possible violent episode. Then there's the episode that happens itself, the violent episode. It could be verbal, sexual, physical, but there's the violent incident that occurs. And then after that violent episode occurs, there's a honeymoon phase where the person who's done the abuse, they're apologizing, taking that person who was abused out to dinner, buying them things, saying nice things to them, complimenting them to sort of make up for the abuse. And it's kind of it's called the cycle of violence. And the reason why is it tends to repeat itself in a lot of these situations of battered spouse syndrome where you see this repeating itself over and over and over again. So people are kind of stuck in these revolving doors in their relationship.
And can one cycle be enough to traumatize a person?
Yes.
Does this trauma necessarily have to be coming from a man to a woman?
No.
And in fact, as times have changed, language has changed, and so when we keep referring to it as battered woman syndrome in the courtroom today, what we're actually talking about now is battered spouse syndrome or even intimate partner violence.
Yes, sir. I mean, interpartner violence can happen outside legal settings, but it's really a kind of the large overgrouping, if you will, to be able to talk about all of these other things that can happen as a result, like trauma-based disorders and battered spouse syndrome. And you're right. The later research has kind of pulled us away from thinking this only happens to women in heterosexual relationships. We know now there's all sorts of derivations, and that men can suffer also from battered spouse syndrome, battered person syndrome, homosexual couples. So we know it goes around to everybody, but still,
humans can be violent to humans.
More often diagnosed with battered spouse syndrome than anybody else.
Humans in relationship to each other can be violent to humans.
No, sir.
Does it have to come in the form of sexual violence?
No, sir.
Can it come in the form of emotional or mental violence?
Yes, sir.
And
They talked about coercive control.
That include such as running the partner down and telling them that they're no good and, just general insulting and lowering their value.
It could. Remember, that's the stimulus, so it would depend on how the person who's receiving that responds to it as to whether or not it becomes traumatic. But yes, sir, that would be the first red flag you'd want to investigate.
And you mentioned isolation before. So if somebody in a hypothetical intimate partner setting is trying to isolate the partner from his or her family members or friends or coworkers, can that be, and I'm not saying necessarily, can that be indications of intimate partner violence that could lead to battered spouse syndrome?
So sure, that would be an example of coercive control. So if a person was doing that, that's consistent with that,
the car,
that classification of battered person syndrome. Yes.
And hypothetically, controlling another person, the intimate partner's personal property or effects, such as a birth certificate or identification papers, can that be indication of emotional trauma towards the partner who is
He's going to go through everything I think they know about Sarah Boone.
So that's a stimulus that could result, depending on how the person subjectively perceives it, in some trauma. So yes, all of the things that you mentioned could be stimulus, if you will, that a person could perceive as traumatic.
And hypothetically, if one partner A gives partner B a gift, such as a bicycle, but partner A continues to maintain that the bicycle is his or hers because he or she bought it, even though it was a gift to B, can that be a form of emotional abuse towards B?
Sure, it sounds like control, but I guess you could interpret it as emotional abuse too, but it sounds more like a control mechanism that would be consistent.
I'm not suggesting that it's legally or morally okay. But when one intimate partner does these hypothetical emotional things, non-physical violent things to partner B, if partner B has poor personal skills and coping skills and may be consuming alcohol, is it unreasonable or unfathomable to hear that partner B responded with physical violence to partner A?
Objection, assuming facts not in evidence.
It's a hypothetical.
Sustained.
That's what he's.
Yes.
Now they're approaching. He's like, you called this witness. I'm going to continue to use this witness to my own effect. So they are approaching on that. The state is, I think,
If you remember,
After hearing argument of counsel.
the state, I think, is using this witness well to their advantage to educate the jury and, just like you're doing in the chat, to have the jury start to connect things they've heard about Sarah Boone to the other side of the coin in this relationship from what the defense is trying to present. I think it's a really, really good cross.
After hearing argument of counsel, the objection is overruled.
So let me respond to that.
if you remember the question,
Do.
please go ahead.
So it would increase the probability of physical violence. So if those things, in fact, were perceived as threatening or abusive in any way or insulting to the person who they were directed towards, it would increase the probability of physical violence.
And then again, the perceptions are all in the eye of the beholder, whether emotional things that are said to one another or physical things are done to one another, whether the recipient of that behavior views it as trauma.
George, the chat would like to say hi.
By that person, right?
Yes, the perception is the impact. So that's how you would know that. It's just, water off a duck's back, or is it something that kind of sticks with me and I think about it all the time?
Now, you mentioned earlier anxiety.
Ooh, George is trying to nope out of saying hi. He's like, I don't want to say hi.
Of battered spouse.
You don't want to
correct?
say hi?
Is it important as the evaluator
George
to
is like, no way, man.
rule out whether or not these conditions
chat just wants to say hi. George is like,
the
no.
violent or abusive relationship?
Yes.
I'm going to go back to the
Why is
window.
that?
Well, because where things start is important diagnostically. So if all of those things were in place, all of the symptoms that were just mentioned are in place, then you wouldn't attribute those to the abuse. You'd say those things were pre-existing. Now, abuse could make it worse, but in terms of your diagnosis, you need to know where things started. So if those symptoms didn't start at the time where there was abuse that was alleged to have occurred, then it's unlikely that it's attributed to that abuse.
And
George is
independent of
like, no
any
cameras.
narcissistic personality disorder traits, would you agree that anybody in a certain legal setting has a motivation to present themselves in a certain way?
Yes, to do impression management, either depending on the outcome. So if they're
Excuse me, expert, what did you just say? What were those words? What were those words? Impression management. Impression management. Impression management. Counsel, are you going to ask him to explain impression management again? Because I think as we've gotten into this realm of what is impression management, everyone remembers Sarah Boone's interview with law enforcement. So I'm going to just back that up. The jury doesn't have the benefit of back that thing up, but I do, so I'm going to.
Any narcissistic personality disorder traits, would you agree that anybody in a certain legal setting has a motivation to present themselves in a certain way?
yes, to do impression management, either depending on the outcome. So if there's punitive sanctions, they may lie to make themselves look worse, or as a result, if they're in other settings, like divorce settings, they may lie to make themselves look better. So there's always some impression management you have to kind of look through in your evaluation.
And that's important for an evaluator?
It should be looked at in every evaluation.
Thank you.
Yes, sir.
That's your impression.
Redirect examination.
I mean, that's your impression that it should be looked at in every evaluation. Sarcasm.
Just want to
That was a good cross for the state. Better
One
than their
more
cross of
time.
Sarah. I think more impactful.
In response to the state's questioning, you indicated that where an individual's credibility may be in question, there is a necessity that the individual who's making the assessment corroborate whatever they're being told. Is that correct?
Yes, sir, in a number of different ways. We have psychological tests that assess for things called malingering or faking mental health problems or difficulties. So you'd want to do that. You'd want to look at other evidence to see if it's all consistent. So it's very important you don't just rely on self-report.
If it's possible that an individual may exhibit one or two attributes of a particular DSM diagnosis, but not actually qualify because it's simply not there.
Right, sure. So sometimes like social isolation can be because we're introverted, or it could be part of depression. So you need to kind of follow it out and see how many of the symptoms are there to see whether or not it meets the criteria.
So I may exhibit one or two symptoms of narcissism, but not qualify because I don't meet all of those, or a significant number of the indicators that you would rely upon.
Based on all the questions they're asking, I'm really beginning to wonder if the person who evaluated Sarah only evaluated on self-report, because they're asking a lot of questions about it.
To make that diagnosis.
Yes, or it can be situationally based, like we may display narcissistic features here in a courtroom, but may not do that in any other part of our life.
Now, in your experience, have you determined, learned, either through your studies, experience, and so on, whether or not the abusive behavior may begin based upon an individual's perception of things occurring to him as a child or her as a child? In other words, if they grow up in an abusive household.
Okay, I understand.
Sustained.
You've indicated that there are things that, I think in response to the state's cross-examination, that there are things that may add to or may contribute to a particular psychosis or symptom. Would an individual's background as a child include those type of criteria?
Yes, sir. You're more vulnerable to certain psychological conditions based on your history. So if you've been traumatized before, or bad situations have happened to you before, if you've suffered from depression before, it makes you more vulnerable to those conditions or other conditions later on.
Finally, one question or one symptom that we haven't discussed, I don't think, or maybe it was discussed by the state, was learned helplessness. What is that?
Learned helplessness, I've really spoken about it a little bit, but now we have the fancy term for it. Learned helplessness was really researched by someone named Seligson, a doctor named Seligson, psychologist, research psychologist. And just real briefly, what it is, it's when someone kind of gives up and feels like there's nothing that they can do to change their situation. It was originally done with laboratory animals. But where a person really feels that no matter what strategy they've taken, like leave, stay, fight, whatever it might be, it won't work. It usually leads to depression or developments of other strategies, like I have to appease or please or make sure I do everything correctly or apologize. So it's really believing that no matter what you do, it won't be effective.
Doctor, thank you for your testimony. Thank you for
Sure.
traveling up here from Miami so early in the morning.
No problem at all.
Thanks for the rest.
Thank you, sir. You can be excused.
Thank you, Your Honor.
Can the parties approach for a moment?
All right, they're going to approach. And while they're approaching, I'm going to put a poll in the chat to ask who you thought made better use of that witness. So who, which side was Dr. Brannon better for? And I'm going to ask you defense or prosecution. And then we will zoom. But I can't do both while my hands are, my fingies are busy. All right, let's zoom as the I imagine they're talking about scheduling. But I think that the prosecution had a very good.
Jury, it is 10:40 at this time. We're going to go ahead and take that mid-morning break.
Morning break.
Similar instruction I've given you over the last couple of days. I'm sure you're tired of hearing it, but I got to keep telling you.
Oh, I should have
Please
put-
don't have
I
any
should have put-
conversations among yourselves or anyone else about the persons, places,
should have
things,
put,
or charge involved in this case. And do not
neither.
conduct any independent research on those things. We'll see you back here in about 15 minutes at 5 till 11. Thank you very much.
Apologies for not giving a neutral answer. So they're going to take a 15-minute break. We're going to zoom past that because we have zoom room, and I would like us to be on time for, well, lunch. So let us zoom past the morning break. and get into them coming back on the record. So we have gotten through, what, 5 witnesses for the defense today? 4 witnesses for the defense today? And 1 witness for the defense
We are
yesterday?
back on the record. 2020 CF 2603, State of Florida versus Sarah
You're
Boone.
after break.
State.
Shore on behalf of the state, Boone J for the state.
Defense.
County Henderson for Sarah Boone.
Kevin back on behalf of Sarah Boone.
All right, Ms. Boone is still seated at counsel's table. Yes, Mr. Owens.
Judge, we had several late witnesses that were scheduled. What was that for this?
Several lay witnesses, not experts, not law enforcement. Civilians.
We've excused Detective Scott Lowen based on the testimony of Detective Koepsell. We've excused Abraham Marino, who was going to be recalled based on the testimony of Detective Koepsell. You've heard from the 2 deputies, you've heard from Dr. Brannon. Maria Gallipoli is a young lady that's outside. She was a witness as a neighbor in that complex, and she would testify about observing physical injuries to Sarah Boone.
Don't think that's in controversy.
We've spoken with her over the break that, in our opinions collectively, Tony Henderson and myself, that it's not necessary to call Ms. Gallipoli because we have other evidence of injuries.
Yep.
There was disagreement about that, but I believe that Ms. Boone is now in agreement that we're not going to call Ms. Gallipoli.
Oh, that was a difference
So
between
that
Boone and
means
her defense
now,
attorneys.
Calling the Orange County Sheriff's Department phone extraction expert.
Ms. Uadan.
Yes, back to the stand, and we've got 2 short videos. These are the short videos relating to Jorge Torres
the
with
TV.
bat and then striking the TV. They're less than a minute apiece. The problem with that is because we've excused so many witnesses, that's our last witness. So we're going to be done here in probably 11:15,
Woohoo!
and then
But Ms. Walker is supposed to be here at 1 o'clock?
that's correct.
Okay, all right.
And then I haven't had a chance to meet with Dr. Harper, but I'm going to meet with her at lunch over next door. And we anticipate Dr. Harper this afternoon. And then we may be really close to ending the defense's case.
Okay, great. Thank you for letting me know that.
But we're going to have a gap here.
A long
Okay,
lunch.
so
Early lunch.
well,
A
yeah,
long lunch.
that may
I want a
well.
long lunch.
If you're saying that
Long lunch,
your
long lunch.
presentation with Ms. Uadan is 15 minutes, I don't know what the cross is going to be. It may be de minimis, or you may be saving her for rebuttal. I don't know. Mr. J or Mr. Cacciatore?
I'm sorry.
As it relates to Ms. Uadan, CSI Tech, you're not calling her in
She already
rebuttal?
made the predicate during her trial testimony during our case in chief for the exhibit. I'm going to put her in rebuttal.
Okay, awesome. So what we can do is we can proceed with Ms. Uadan, and we could just take an early lunch and ask them to be back here maybe 12:50. So that way, if we have any issues, we can address them before we start at 1 o'clock. Ms. Boone, you were sworn this morning. I just got a couple of things to go over with you. There was a list.
So they are going through scheduling. I'm going to bring the volume back down now that we are not with Owens not near the mic. They are dealing with some scheduling. Their doctor won't be here until the afternoon after lunch. They need to talk to the doctor over the lunch break. So they are bringing in the digital forensic examiner that already testified, and then they are going to bring in videos, it seems, of Jorge Torres smashing the TV. And then we'll go from there. But it sounds like there was a disagreement between Sarah Boone and the defense about this neighbor witness. Sarah Boone, it sounds like wants the neighbor to be called because the neighbor saw injuries to Sarah Boone. The defense, it seems like, has talked her out of that. I wonder if this neighbor had also seen injuries to perhaps George. So that might be one of the reasons they are trying to make that decision. The defense attorneys get to make that decision, not Sarah Boone. If they don't want to call the witness, they don't have to call the witness, no matter how much she wants to call the witness. So the court's going to do a colloquy, and then we'll get into that tech. And then it sounds like we're going to have a long lunch today, which sounds good to me.
list of witnesses that was provided to the court last
They've
night
narrowed
and
down
again
their
this
witness
morning
list.
as potential witnesses that may be called in your defense. One of those witnesses was Maria Gallipoli. Your lawyers have advised that they may not be calling that person as a witness in this case. Do you understand that?
I do.
And again, similar to other conversations we've
They
had,
get to make that choice.
I don't want to go into any specifics of any conversations that you've had with any of your lawyers, just whether or not you've had them. Have you had conversations with your lawyers about calling Miss Gallipoli as a witness?
Yes.
Have you had conversations with your attorneys about why they are deciding not to call her as a witness?
Yes.
And similar to what we discussed yesterday, do you understand that your attorneys make the trial strategy decisions, including what witnesses to call or not to call?
Yes.
Okay. Are you still
Okay.
satisfied with their representation of you in this matter?
Yes.
And are you still on board with the strategy that has been employed in your defense?
Yes.
Are you in agreement with the strategy not to call Ms. Gallipoli as a witness in this case?
I am.
Okay. All right. Thank you very much, ma'am.
It seems
Then-
that the court is going well out of their way to limit Sarah Boone wilding out on appeal. And it seems that these attorneys, though I have had critiques for the defense, that the attorneys have done a good job of client managing Sarah Boone, which cannot be an easy task. It might be why there's 4 attorneys, but it seems that they are doing a good job of making sure she feels heard and making sure that they well explain to her what decisions they're making and why. So I think that's why they are really honing in. But Valerie Frank in the chat said, Emily, have you ever seen anything like this? I have never seen a judge colloquy a defendant like this, ever, just ever. And I think because the judge has dealt with her for 4 years and dealt with her as a pro per, he knows, and this is his strategy to make sure that she can't come back and say, I didn't want these attorneys. They've, I don't agree with what they're doing. I wanted to stay self-represented. But she said very much on the record she did not want to represent herself. So I've not seen a judge go this far in that, but I think it's a good strategy. It takes, what, two minutes? So 2 minutes to protect this down the road makes sense
And
to
let's
me.
go ahead and bring our jury back in, and we can call Ms. Uadan and go from there.
All right, one more witness and then a long lunch.
Excuse Ms. Gallipoli.
I'm
All right,
here
thank you
for
very
it.
much. Let's go ahead and stand and bring back in our panel.
How do you spell Gallipoli?
What I have, Galipoli.
The court reporter asked, how do we spell her name? All right, the jury doesn't seem to be back in. We're gonna zoom a bit more.
As our members of the jury, once seated again,
There we
you
go.
can confirm that you complied with the court's instructions during our break by raising your hands. Record reflect all hands have been raised. Defense, you may call your next witness.
If you are curious what I'm doing, yes, I'm looking to see if I can Uber Eats myself some muffins. Don't you worry about it.
Forensic phone extraction. Officer
Highly suggestible.
with the Orange County Sheriff's Department, Officer Uadan, to the stand.
Thank you. We'll bring her in.
Twisted Life said, ooh, I'm behind. I just got to muffins. Hopefully that'll be me soon. So this is going to be defense witness 6, I think. On defense witness 6? Yes, defense witness 6. Thank you, Julie. And this is a recall of a witness. I've seen a number of you ask if Sarah Boone can be called in rebuttal. I've never seen a prosecution attempt to do that. She waived. She waived her Fifth Amendment rights, but I've
Good
never
morning, ma'am. Could you
seen
state and spell your name for the record
the
for us?
prosecution try to do that. I don't know how that would go in this court. So
First name is Junella,
I wouldn't count on it.
Junella. Last name Uadan, U-A-D as in Delta, A-N.
Counselor, you may inquire.
thank you for speaking into the mic.
Again, your official title,
Digital Forensics Examiner.
and are you referred to as a detective, or what is your?
Just an examiner.
Ma'am, Judge, can I approach the witness?
Yes, of course.
How about ask a question before you approach?
What has been marked
Wandering poot.
Station Defense Exhibit 8A. And you recognize that video, or that CD of the video?
Yes.
Well, I think we kind of prepped you on it ahead of time. That was extracted from the Sarah Boone phone that you were asked to extract.
Search Uber Eats.
Yes, one of the media files, yes.
Okay, and is that video a fair and accurate depiction of one of the videos that was extracted from Sarah Boone's phone?
Yes.
Search Uber Eats for muffins. You know what comes up first?
See, defense identification.
Duncan.
Same type question. You've had a chance to review that video, and is that one of the videos that was extracted from the Sarah Boone phone?
Yes.
Judge, this time I'd like to have these introduced into evidence.
Any objections?
No objection.
All right, what was pre-marked as AA will be received into evidence without objection as defendant 17. What was pre-marked as Z will be received into evidence without objection as defendant's 18.
It's 100% that's what I'm ordering. It needs to happen at this point. It's for the research. We're doing it for the trial. Duncan apparently has blueberry coffee cake and pumpkin muffins.
You may proceed.
And is there a volume? Judge, do you have control of the volume?
Volume is on.
All right, it looks like they are going to play the video extracted from the phone that the defendant took of Jorge Torres with the TV. They didn't show this video yesterday.
You're gonna help me take this shit out. Real shit. You're gonna help me take it out. You're gonna help me take this shit out. As bad as I want to.
Okay.
Judge, I'm asking to publish Exhibit 18.
You may proceed.
And then a second video, I guess. It seems highly ill-advised with dogs.
We spoke about it earlier.
Say again, sir.
We spoke about it earlier.
Yes, understood.
They're tendering no cross.
All right, thank you very much. All right. This witness can't be released, correct?
Yes.
State.
Yes, sir.
Thank you. All right, can the parties approach momentarily, please?
Okay.
Members of our jury, at this point in time, it's 11:08.
Was the TV broken? Because he's talking about taking it out and then just beats it with a bat, but seems exhausted doing so. That was odd.
I know it's a little bit early, but due to the pacing and how quickly we've been moving through the evidence this morning, and how the defense has teed up their witnesses for this afternoon, we do not have anyone until 1 o'clock. So at this time, we're going to go ahead and take our lunch break at this time.
And because we planned for Zoom room, we only have about an hour of break for lunch. So though it's a bit early, depending on what time zone you're in, good morning, happy breakfast, West Coast, but we're only going to be breaking for about an hour. So I'm going to let the court excuse the jury. We're going to give a bit of a summary, and then we're going to go to lunch.
I give you a similar instruction that I've given you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to ask you to return here to 12 Alpha at 12:50, and we'll pick up shortly thereafter. Thank you so much for your service.
All right, we're going to be going to lunch shortly. And then we will be getting to the defense's last witness. They're going to lunch till 12:50 local time. We will be doing the same, but it'll be 11:50 local time for me. So about an hour from now, I'm going to answer a few questions.
Thank you. State, anything we need to address?
Nothing, thank you.
Defense?
No, sir.
All right, we'll see you all at 12:50. Thank you very much. Court's in recess.
All right. Court is in recess. This is why we love the Zoom room. Otherwise, that break would have been a substantially longer lunch break for us, and we got through it. And, you know, post Yachtly, Emily appreciates the extra bit of time this morning, even the extra bit of time this morning. So they are going to be going to lunch. I already said that. I'm going to do a quick summary. It looks like the defense will be speaking to their expert over lunch. So do they have a ton of time to talk to Sarah over lunch? One of the attorneys will, but the other attorneys will be prepping for lunch. So we will see what's going on after lunch, and that'll be their last witness. So Zoom, which means tomorrow we will get to the state's rebuttal case and possibly closing, depending on how many they have in their rebuttal case and what they bring for the rebuttal case. So I see a number of you in the chat saying you think the video undermined the photos of the TV. It's not he is hitting the TV with a bat, but it's not a scene. It is just it's just happening. So she's not saying anything. I think it might have done more harm than good. The jury can also see how out of breath he is wielding that bat. And also they see his stature a little bit, and they see them, together. So it is what it is. All right, let's do a quick summary, and then we will go to lunch or breakfast or nightcap, depending on where in the world you are. So let's see if I can summarize this morning. The defense seems to be almost through their case in chief on day 4, at the lunch break of Florida versus Sarah Boone. They called a number of witnesses this morning, lots of law enforcement witnesses, to quickly go through corroboration of Sarah Boone's reports of prior contacts with law enforcement and law enforcement coming out when there had been calls relating to domestic violence. Law enforcement corroborated the things that she said in her testimony. When they came out with the incident where she had the black eye from being kicked, they corroborated that when they came out, she had injury to her face and reported that she was kicked and said that she fucking fought back. That's what she said in her Ooh, I ran out of air. That's what she said in her testimony yesterday. We also saw Sarah Boone corroborated with other law enforcement, and we saw the defense eliciting that on some of those instances, she had also been arrested and got out ahead of that, but we knew that. Then they called a forensic psychologist who did not evaluate Sarah Boone to talk about battered person syndrome in general, to talk about intimate partner violence in general. And I think that was maybe the state's best cross-examination so far. The state used that witness to explain things like narcissistic personality disorder, alcohol abuse disorder, and other disorders. And they used this witness to go through what a thorough and complete evaluation for a trauma-based disorder would look like. I wonder if when we get to the defense's other expert that did evaluate Sarah Boone this afternoon, if we're going to see that some of the things the prosecution was asking about are because they were not done by the defense's expert. They said you need more than just bringing in a self-report from the individual. They also talked a bit about perception management, and it was interesting that we got to that conversation in all of this, because honestly, some of the things that the prosecution brought up, you're sitting there going, yep, that's exactly what we saw in Sarah Boone's interview. And I think that's probably what the jury was nodding along thinking too. This is a complex case. There is a lot going on with clinical psychologists. We will see, and forensic psychologists, we will see what they evaluated Sarah Boone and or diagnosed her with and or did not diagnose her with when we get back after the lunch break. All right. Are we ready to do some questions? I'm ready to do some questions. Good to see you. Let us get to your law nerd questions. All right. B2 said, sending out very happy birthday vibes to our dear Leila Quinones. Leila. I've hopefully pronounced that properly somewhere. Happy birthday. And B2, thank you for the birthday shout outs. Jessica said, love the trailer. Great job, Team Baker. That was 100% Team Baker. So the editors, our production side of Team Baker is growing, and that was put together by the editors. My hope with having the trailer before the stream is that if anybody was coming into this case fresh, they would have at least a rough overview of what the case was about. So that was my goal. And thank you. We've never used trailers on YouTube before, so I love the feedback that is helpful. It's just like adding the daily summaries on QuickBits. It is my goal that they are helpful to keep you in the loop. And if it's like, oh, what did I miss? At least there's a summary there on QuickBits. And oh, what did I miss? There's a summary up on the audio feed every day. So if you're like, hey, I just want to pop this on, I can't listen in the background on YouTube, I just want to listen in the background, those summaries are also up on the Emily Show podcast audio feed. So the audio feed has QuickBits and it has those daily cut downs too. Victoria said, I was listening to EDB on my way home from work last night, but when I got home, the fire brigade had evacuated my street because one of the houses opposite had set fire. Oh dear. Well, I'm glad everyone got out. So I'm glad everyone got out, and that would be incredibly stressful. Hello from aboard the MSC Orchestra, coast of Spain. Sounds amazing. And also, go enjoy Spain. Rolling Along said, in my opinion, the prosecution got caught flat because they didn't think she would get the battered spouse in, so they didn't know how to cross. I mean, they didn't know how to cross her, but they did a great job with the expert, I think. But they did not do a great job with the process of Sarah Boone. So that is, I think that's where we're at. Music to My Soul said, do you think the prosecutor was thrown off and cross yesterday because Sarah Boone was allowed to proceed with her self-defense? They should have been prepared for it, though. They wanted to keep it out, but they should have been prepared. Scintilla of evidence is just a little bit. They had to prepare for both, and they had time to prepare for both. And they knew what Sarah was going to say when she got on the stand. They had to be prepared for both. Ruby said, on the train to Chicago for a concert tonight. Enjoy. Concert season is my favorite season. Wait, did I miss the cross of Sarah? Nicole, yes, she was crossed yesterday. I mean, it was just like, Abda said, not medical advice. Official recipe is hot water with lemon and honey. I will be doing that later in the day. If you're Irish, you get to add a drop of whiskey. I will probably do that later today. My doctor made me gargle with warm salt water an entire glass every hour. It definitely helps with the voice. My voice is not too bad. Today it's a little cranky with me, but not too bad. Elizabeth said, I think we're so used to lollygagging that efficiently questioning witnesses is startling. I mean, it's refreshing how fast. I'm surprised at how fast it's going. It's going well, but it's so fast. So fast. Let's see. Casey Cat said the prosecutor stated on his way out of court yesterday, the rebuttal will be longer than planned. Well, I think they planned for the defense to be kept out, but yeah, it will have to be more experts, I think. Lida asked, Emily, do the jurors know which 6 will be deliberating? I don't believe so. I think all of them are sitting there, and then the deliberating jury will be selected. So that's because I haven't seen them select them, but if they are by seat number, they might assume if I'm in seat number 1, I'm deliberating. So we'll see how it goes at the end. Happening said, I'm confused. So he is testifying as a non-expert. Yeah. I mean, yeah. But then the state was asking him hypotheticals. So like, okay. So there's things that happen in this case that I just don't understand. The lack of identification constantly is making me wild. So Nathan said, when time allows, can you please explain the value to a case of the opinion of an acknowledged professional versus the opinion of a recognized expert? I don't know if the jury will even perceive a difference. Honestly, he has education training. He's testified in over 1,500 cases. I don't know if the jury will even notice the difference at all. I saw the question in the chat from Ray Phillips. Why are they taking her out in chains? She is an in-custody defendant. So with an in-custody defendant, she goes back into the local lockup in and out of court. She is unshackled while in court, while with her lawyers. And when she is not in court, she is shackled. So hopefully that helps. Thank you, Miguelina. Let's see. Dr. Brannon is almost explaining BSS with a conscious choice, which I don't necessarily agree with. I would have to go back and watch the testimony again, Katie, but I don't disagree. He kept saying strategy. So I can see, I had to like in my mind try to be like, what was he saying? He kept saying strategy, but he wasn't saying coping mechanism. He was saying strategy, and I can see how strategy can sound much more like I'm choosing, I'm planning, I'm plotting versus, oh gosh, my in-ears are caught on my necklace, versus a coping mechanism, versus a subconscious or unconscious coping mechanism. I can see that. Emily's going to fight with her in-ears during the break. Danielle said, do you know the Muffin Man? I mean, we do now. This is the Muffin Man now. You're the Muffin Man now, Dr. Brannon. Stephen, good to see you. Did they explain if IPV is different than battered spouse? A little bit, because they talked about IPV being more the relational situation between the two, and battered person being more of the response or the coping mechanism, I think. I hope that they did. Patty Hearst, Dunkin' Donuts, I just need a what if any. There were some what if any's earlier. They wrote a book about me reading the DSM. Allie Katsia. That's hilarious. Lots of the chat are well familiar with the DSMs, myself included. But we have a highly, highly neurodivergent chat. So, neurodiverse folks of the world, We see you. Casey Cat gifted 10 memberships. Thank you very much for the gifted memberships. And to everyone who's gifted memberships, Hazen, thank you so much. Sammy is random said yesterday I kept getting Depp Heard flashbacks. We definitely have we've definitely been getting moments that cross over. Like totally gifted 5 memberships. Thank you. Colleen gifted 5 memberships. Thank you. The muffins are a staple since the Depp trial. I mean, we've not had it come into another trial quite like this, but that was, I was not prepared. It's why live trials are the best, because you never know what's going to happen. Crazy Panda Lady said, I question whether George was trying to leave Sarah and was trying to pack his suitcase when all of this happened. Obviously, there's no way to prove that unless he told somebody contemporaneously. There isn't. Her story is that these were things that were being donated. I'd be curious, though, what the paperwork was in the suitcase. Because you're not necessarily donating paperwork to Goodwill, especially if it's personal paperwork. So it's Crazy Panda Lady. It's a fair, absolutely fair pondering. The stills from the video made me think the video would be much worse, especially the picture of him pointing the bat at her. Yeah, and the video was not. And I think in the prosecution's rebuttal, we'll see some of the body cam footage from police coming out on some of the instances. So thank you, Miguelina. I appreciate that. Let's see. Do we have a new Remarkable review? Did I miss it? I don't have a new review yet. I'm trying to use both the new one and the Remarkable Pro and the Remarkable 2 and go back and forth and see where we're at. So no. Flying Ryan said, what's your go-to drink from Dunkin' Donuts? I don't have a go-to drink from Dunkin' Donuts. I am not a Dunkin' coffee person. As I said earlier, I have, I visit Dunkin' for pumpkin donuts and that is it. I didn't even know they had muffins, but I, occasionally the snacking bacon, but not really coffee. I am just been a long time Starbucks coffee person, but today I am a homemade cold brew person. So that's where we're at. With that, chat, I think we've gotten to most of the questions, and not all of the comments, but most of the questions. I'm going to take lunch. I absolutely need it. I'm going to probably pull my hair back because it is making me crazy today, and I just can't stop, won't stop. It's getting stuck in my ears, and I'm overtired, so it's too stimulating. I can't. It's got to go. It's got to go. We're too overstimulated. We will be back from lunch in a little less than an hour. So chat, we will leave the chat open. I will be back when court is back. If court runs a little bit late, I'll let you know in the chat if I am running late with them. But I will be back when court is back. The jury is coming back at 10 to 1 Eastern Standard Time. So I will be back at 10 to 12 Central Standard Time, a little less than an hour from now. We will also update you in the app if you have the Lawnerd app when we are back. And then we will roll through the afternoon. I do have a meeting this afternoon, so I will have to pop out briefly, but do not worry, we will be all good. I will see you soon. And Lawnerds, today the chat, well, no, today the defense might rest. So, close the poll. You're right. Chat is bae. Which side was Dr. Brannon better for? Defense, 20%, prosecution, 80%. So a lot of you thought that the prosecution made much better use of that witness. We'll see what happens with the next one. And with that, Lawnerds, it is time. I will see you soon. Have a good break, stretch, get some water, do all the things. And I'm gonna bounce. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days.
Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch,
Take care of yourself. Trial days are long days.
Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed.
Hello, law nerds. Hello. Court's not back yet. They were supposed to be back 5 minutes ago, but I figured we could just chat for a minute because I was actually ready to be back. And so once in a while, we should just, change up expectations and be relatively moderately on time. My hair was making me crazy. So back to the messy bun it is. And court, well, not back yet. But once court is back, we will be back in live court. I'm going to answer some questions and super chats while we're hanging out. Yes, I got DoorDash. No, Uber Eats. I mean, same. Yes, I got food. Is that food what I ordered? No. Why? Because they sent blueberry muffins. Blueberry's not pumpkin. Like, blueberry is so specifically not pumpkin. Blueberry's not pumpkin. So there's that. I need to check the ingredients on that because some blueberry muffins have oat. I have an oat allergy and my face will turn bright red, like just bright red. So Julie's like, oh my God, I was just having this problem. Yes. It looks like they are going on the record.
20 CF 2603,
So I'm going to
State
unmute
of Florida
them.
versus Sarah Boone. Let me get appearances for the state.
I guess we'll talk snacks in a minute.
Defense.
James Owens for Sarah Boone.
Let's see if there's anything the defense needs to take up before we get back, all the way back.
Ms. Boone is seated at counsel's table wearing the same dark gray suit and
It's disappointing.
maroon
My
blouse
kids will eat
from
it.
this morning. She is in custody. However,
But-
there are no restraints. She will be
it's okay.
standing
We'll
as
figure
the
it
rest
out.
of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
Are we surprised? No. Your Honor, I've got something. Can we approach? But they are in their case in chief. They have, to their credit, moved this case along very quickly. Like, very quickly. So I'm not surprised before their last expert comes up that they might need to approach to talk about things because they might just need to go over what this expert's going to testify about, but we have no Zoom room. I'm not surprised. We'll continue to ask questions. So Intercoastal said, did the state just give up? I don't think so. I think that the state was very much engaged with that last expert. I think the state has a plan for their rebuttal case. I don't think the state has given up at all. If anything, my concern about the prosecution might be that they've had this case for so long, they are overconfident, that they see it in a very specific way, and maybe not everyone seeing it fresh will see it that way. They've lived with this case for 4 years. They see it, they see it with the, lens of they've been in it for a long time, and they know this case very well. They've interacted with Sarah Boone in court. They've interacted with all of her letters to the court. Like, they have a much broader picture of Sarah Boone as a person than they do, or than the jury does, right? So overconfidence can be a problem. And also knowing your case so well, you're like, of course everyone will see it the way I do. No, they won't. No, they won't. A jury won't always see it the way you do. You have to show them the puzzle on the box well. And if you don't do it well, they might not see it that way. Patera in the chat asked how long till deliberations starts. I don't know. It depends on when they're done. So I think the defense will be done today. I don't know how many witnesses the state has in their rebuttal. Probably a day, given everything. If it's a half day, the jury could start deliberating as soon as tomorrow. But I think we'll see jury deliberations Thursday, Friday, because if the state takes a full day in their rebuttal, we should know better at the end of court today. If the state takes a full day in their rebuttal Thursday, then we'll see closing and deliberation Friday. But this case has moved along essentially in a week. So we could get all the way through verdict this week or verdict on Monday. I don't know if they deliberate in this jurisdiction over the weekend. I hate it when courts do that. I mean, maybe juries like it, but it seems so awful to be court staff and have to constantly be on call. And especially for the attorneys, everyone works hard during trial, but to not have the rest of it's Saturday, just let me breathe, would be awful. Also, you have to plan things. When you're in trial, you have to plan your whole life on Saturday. Nashay asked, how old is Sarah Boone? Her birthday is 10/10/1977. So she would have just turned 48. Am I doing the math right, chat? 47, 48? 47? Just turned 48? I don't know. In there, 47, 48. 47? I can't math. So we're close. less than 50. Amethyst said, Emily, I'm wondering where the music on your court is on break screen comes from. It's like a fidget toy for my brain. I could listen to it forever. We pulled it from StreamYard. StreamYard has royalty-free music, and we looped it from StreamYard's royalty-free music, though I am very much considering making some custom music, but it is a lo-fi StreamYard music, so that's where we pulled it from. So hopefully that helps. Finishing off my homemade pumpkin bread for breakfast, guess what we're doing this weekend, chat? This is what I need. I need to make pumpkin bread like with a little bit of cream cheese woven through it. Emily, you have to go to band competitions this weekend. Shh. I also want to make pumpkin bread. Emily, you have to finish unpacking from fall break this weekend. Pumpkin bread. Emily, you have a list of shit that you have to do this weekend. But pumpkin bread. Mr. Crowley said, great coverage, Emily. Thank you. Now I'm hungry for muffins. I'm highly suggestible. I'm also hungry for muffins. Wendy DB says, oh my God, my son lives in Manhattan Beach. The donuts there are like no other. I think most of them are Vietnamese families. Am I correct? There are some Cambodian families. The donuts deserve a super chat. They are amazing. So yes, different family owned, some Vietnamese, some Cambodian, and amazing. Maybe we'll talk about it on our members only live tonight. For those of you that got gifted membership, there is a members only live tonight. I have it set for 7:30. My teen has an appointment. If we are a little late, I will keep you apprised in the chat and in the app if I am running late, but it should be good at 7:30. And we can talk about me being highly suggestible, but we can also, if you want, chat about the donut procurement that would happen in high school. My senior year of high school, I'm not great at math. I had the most basic math class. The math class that people would be mocked for taking. Yes. It was the 90s. Kids were not always kind. Being neurodivergent, especially as a female, was not always treated with any type of respect. So when it's like, Emily, what kind of childhood trauma do you have? It's like, well, we'll get into it later. But taking low-level math where you have junior high school students in your math class as a senior is definitely one of those things. However, here was my strategy. I already knew where I was going to college, and I needed my GPA to not eat shit. So I needed to make sure I was in classes that, even though I didn't give a shit anymore, because senior year, I was just like, college now, please. College now, please. College now, please. So even though I knew where I was going to college and was ready to go and play water polo and, do all of that, I did not accurately perceive the winners in Western Massachusetts with that level of excitement. That level of excitement did not match the winters that would then be encountered. But I had swim practice and water polo practice in the morning before math. There was a girl in my math class who complained about this literally every single day. When there is a complaint about something, particularly the fact that I smell like chlorine facts for a good portion of my life, I am going to sometimes just double down on that, because I will meet you with
Thank you all very much. Mr. Owens, if you can.
And in meeting with Petty, I started just not changing after swim practice in the morning and literally rolling into math class in a swimsuit, wet hair, with a donut, in a towel, maybe in a pair of pajama pants, probably flannel Beavis and Butthead pajama pants. And every single day was like, she reeks like chlorine. And I get that smells can be a thing, but I smelled like chlorine whether I showered or not. So I was like, fine. You want to complain that I smell? Move your seat. Go sit somewhere else. No, you want to sit here so you can make little snippy comments. Fine. Talk your shit. I'm going to sit here and reek like chlorine with my donuts. And then she'd be like, she's late. Yep. Was late because I would go get donuts, because I would go get donuts. And my math teacher was just like, we're just going to let her do her. Like, if she's not disruptive, we're just going to let her be. So me rolling in my towel and a swimsuit, because Southern California with wet hair. In Massachusetts, when I tried to roll around to class with wet hair after showering, because the chlorine on skin is not great, it would fucking freeze. It would freeze. My hair would freeze. It's a story for another day. Let's get back into trial, shall we? Because court is back. I was going to answer questions, and then donuts. We love snacking. We love Snackies. Now we have Zoom Zoom room.
See to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Yes, sir.
What? I thought we all got back here early so that the fucking doctor would be here. Why are we advising the doctor to be here at 1:30? Why is the doctor not the fuck here? Now. You told
Just
everybody to come back. Why are we waiting?
Wait for Mr. Owens to return.
Why are we waiting another 30 minutes? No. I will say that we have been incredibly spoiled with how quickly this trial has moved. So my annoyance is really in that it was well understood before lunch. That freezes on the stream. It was really well understood before lunch what this judge's expectations were and what they...
Without Mr. Owens? Yes. Sure.
And what they expected from their expert. That was that they needed to talk to their expert over lunch. This was all very much clear. And now they are not going to be starting with this doctor testimony for another half hour. If they don't bring the jury in and we have to go to break, we might just have to take a break until the doctor starts testifying. And if we need to do that, we'll do that. And we'll go to break until after the doctor starts testifying. For those of you in the chat who are like, I'm in the middle of 900 things. First of all, Lucy, thank you for the gift of memberships. Members, you will get a new tab in your YouTube and you will be able to see the members only live tonight in your members tab, 7:30. I'll also send a notification in the app to remind you to go check. So if you are in the app just generally, you'll get like a little message notification for that. But if we have to take a break.
All right, as we've discussed, we're not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, Your Honor.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
Okay, so they're going to go with Walker first. Okay, so they're going to go with Walker first. Elemental Divinity said, what does redlining mean for jury instructions? It means they are going through and editing some of the things that...
I've called her 3 times. I did text her. I don't know if she's in the process of switching rooms.
No worries. We'll cross that bridge at 1:30 if she's not here, sir. Okay. All right, let's go ahead and stand and bring in our jury.
It means they are going through the jury instructions to modify anything, to take anything out. Sometimes jury instructions have multiple parts that don't always apply to a case. So it's just their suggested edits. So the red line is their suggested edits and the defense will make their suggested edits and the court will bring them together. Some jury instructions are like this and or this and or this and or this. So you have to redline the stuff that doesn't matter. And then there's stuff you have to edit in. There are computer programs for that, but sometimes it is just easier to print it out, redline it, and give it to the other side. So the jury instructions are a group project mixed with adversary. An adversarial group project mixed with an adversarial process. I want this and I want that. It's like a contract negotiation. It's like a contract negotiation, Emily. So it's that. All right, bringing the jury in. Rebecca asked in the chat, is the doctor the state's witness or defense? We are in the defense case in chief, and when witnesses take the stand, we also try to pin it to the top of the chat.
State, you recognize our jury.
We are in the defense case in chief.
Defense, do you recognize
all these
our jury?
witnesses are the
Yes.
defense
All right,
witnesses.
everyone can be seated. Thank
Are
you.
being called by the defense. So they are defense witnesses at the moment.
Members of the jury, again, welcome back. I hope you enjoyed your lunch. I see juror number fifth from the right to left, second row. His hand's already out. He knows what's coming. If you can, just raise those hands, confirm you comply to the court's instructions. Record reflect all hands have been raised. All right, members of the jury.
I love that the juror sat down and was like, yes, I listened to your rules. Let's go. This jury has been like, let's go an extra hour. Let's do whatever. But I love that it was just like, yes, let's go. The juror sat down and was like, I'm ready. Let's roll. Hands in the air. I love it.
Jury, the defense is going to continue with their
it.
evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Mr. Corporal Walker.
I see a lot of questions in the chat about whether or not the defense will call Brian Boone. It seems like they are not going to, but the prosecution might call him back to the stand. Because Brian Boone, I imagine, has a lot of information because Sarah Boone would go to his home when she was having issues with George. So I imagine that he will. Isolated in Alaska. I didn't know this. Fun fact, chlorine doesn't smell. You're smelling its reaction with body fluids. That's delightful. Recent nerd video from Mark Rober taught me this. I will have to go look at Mark Rober's recent video. Interesting because, yes, the chlorine, especially anyone who has been an aqua jock knows the chlorine lingers in your body much beyond or on your skin, even when you shower, even when you do X, Y, and Z. So I'm interested to see what they are. This is not their expert. Their expert won't be here till 9:30 or 1:30. My brain just glitched. Courthouses, I think, have generally done a really good job of doing ADA modifications. In the past, that wasn't the case. Some courthouses are quite old, like we saw in Massachusetts, but some have elevators or lifts, and some don't. I appreciate that they've got the door in the back. So, all right. I really want to know. I'm already like, you be nice to this woman. I already like her.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record for us?
Walker. Bearl Walker, Walker.
Thank you very much, ma'am.
Beryl
Mr.
Walker.
Beck, you may proceed.
Hey,
Good
ma'am.
afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
Okay. How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself. And I will
Okay.
do so.
Okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long?
This is the neighbor they weren't going to call and then now have decided to call. So before lunch, this witness was not going to come in. And they did a whole colloquy with Sarah Boone about her not testifying and Sarah Boone agreeing that she wasn't going to testify. And now she's here. I wonder if Sarah over lunch was like, we're calling this witness. But she has iconic glasses, so here we are.
Long the two of you shared the same apartment complex, apartment buildings.
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with with her dogs.
And what do you mean by call her over?
Hey,
when
baby,
I see her
can I see your
walking
dogs?
with a dog, and I see her and I look at her, And I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Yes.
And how, well, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes.
Have a neighbor chat.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the two primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. I have a mark on her arm. And I just asked her.
And would she describe how that happened?
She just say, I had a...
Hey, hang on. The objection is sustained.
There's a hearsay objection. I'm going to pause. Real quick because there's going to be some questions about why there's a hearsay objection here when the prosecution can allow in hearsay from Sarah Boone's statements. It's because it's not being offered by a party opponent. So when you are talking about the statements of a party, Sarah Boone is a party, her lawyers cannot offer Sarah's own statements. There may be a hearsay objection to that, like, hey, it clarifies what she saw. There might be some type of exception to the hearsay rule there, but generally you cannot elicit your own party's statement from someone else. If Sarah wants to talk about it, Sarah can get on the stand and talk about it, but you can't have the neighbor give that information. If the prosecution is going to ask a witness, what did Sarah tell you? Then it's the statement of a party opponent, and then it can come in. So that is why when it's being elicited by the defense of a defendant's statement, unless there is an exception, it's not going to come in because it's hearsay. Hopefully that helps.
When you would ask her that,
Law University with
how
EDB.
did she appear to you to respond emotionally to your questions about her injury?
How would she respond to you emotionally? How would she respond to you psychically?
One
Objection.
of them days or something.
Objection sustained.
How would she respond to you emotionally?
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her
Counsel?
obvious upset persona?
Objection.
Her upset, the fact that she was upset? Would you ask her about that?
Yeah, well,
Okay, you have to just limit your answer to the question. Would you
What?
ask her about that?
Don't ask this woman dumb questions.
That issue? About why she was upset?
yeah.
Okay. I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place, and and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No.
How long have you been gone from
Relevance?
that apartment complex?
Relevance? It's only relevant if she moved out before Sarah Boone was arrested.
If you don't know, that's fine.
It's been a
Thank
Yep.
you, ma'am. During
Just ask if she
the
moved
occasions
before
that you
or after
had
2020.
to interact with Ms. Boone, how did she treat you?
Objection character.
nice lady,
Overruled.
nice to me.
Did she ever act uppity?
What?
Objection, relevance.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look
Yeah.
down on you as a person?
Oh, no.
Did she ever treat you with disrespect?
No.
I'm going to object. This is character evidence.
Sustained.
May I approach on this, Your Honor?
Yes.
I think the defense, first of all, I fucking hate the word uppity. I think, especially the way it is leveraged against women, especially women of color, I think that the defense attorney is trying to get to negating the NPD. So I truly think they are trying to get to the narcissistic personality. And I think they are trying to show that she was not acting in a narcissistic way towards this neighbor. So I think that that is what he is trying to get to. I think there's room for better word choice there. Like, was she ever aloof? But she was pleasant. Was she pleasant with you? Okay. Was she pleasant with you? That's all. Because I think they are truly trying to negate the NPD. But again, we'll see. This neighbor seems to like her and was worried about her and was concerned for her. And I don't think we would see that genuine concern from the neighbor if she did not like Sarah Boone. But again, the chat, you were saying it over and over and over again, perception management. If Sarah Boone was only having interactions with her dog with this neighbor, there's no reason this neighbor is conflicting with her. So it is, I think, trying to go to the NPD. That's my thought. I might be wrong. We'll see how they get to it, but I don't know if this if counsel has a better word choice for it, but we will see. I think he's trying to get at her being aloof or disdainful or judgmental, but I don't necessarily think it's going to negate what the jury may or may not think from the last expert. But it does tell me that the defense is mindful of what the last expert's testimony can be seen, the perception management can be seen to the jury. It might ring to the jury that some of Sarah Boone's interaction with law enforcement when she's confronted with her own statements was not good. But why would she be, I don't know, snobby to, that was my line. Why would she be snobby or aloof to her neighbor? There's nothing to gain there. Her neighbor's not pressing her on anything. Her neighbor is just having a chitty chat about the dogs. And it was sustained that they are not.
I'm sorry, I'm back, Mrs. Walker.
Going to be allowed to get into.
In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No, sir.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been
Objection.
under the influence of alcohol?
It goes to speculation.
No, I can't say.
Right. Because it's
Did you also observe Jorge Torres during the time that you lived together, lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone?
I think the state didn't object to the alcohol because it might have been obvious as it was to the other neighbors. So they were just going to let her say what she said.
With a black eye?
Yes.
Chat, I'm going to have to bounce in just a minute for a meeting. So I'm going to let the chat and let the witnesses witness, as opposed to putting a hold screen up, because I think they're just going to get to their doctor.
Did you witness
It is a very short
pattern
meeting.
between Ms. Boone and Mr. Torres?
Calls for speculation.
Wherein you observed signs of abuse?
Objection, foundation.
Sustained.
Yeah. Pattern.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Sir, she can't hear you well. Just following up rapidly with, is that accurate, doesn't help. Slow down and stop asking compound questions.
Was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked.
And she said that.
Okay.
I don't know if this witness
Did Ms. Boone
helps
complain to you about those marks?
much. That's what you're saying. But
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there, 'cause we always sit out there.
right.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
I don't know if that's helpful on cross. You're going to elicit hearsay. And you did it.
On the weekends, I see him and her go in.
Okay.
Going.
But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or no.
I can tell
Oh,
when they
counsel. You
must
did
have had
that.
an argument or something. I hear the dogs barking.
Yeah, counsel.
And you're
you did
5
that.
doors down, right? Unit 8, Unit 3?
Yeah.
I mean, it
No other
depends
questions?
on what side they are.
Any redirect examination?
No, Your Honor. Thank you.
Can
I
this
would have
witness be
asked.
released?
I would have asked with, what do you mean you saw them
Thank you
going?
very much, ma'am.
I would have followed up on that.
Ms. Walker, the deputies are going to come get you and
I would have
take you out,
followed
okay?
up on that. All right, chat. I will be back.
You all
I don't
done?
think that
Yes,
was-
ma'am. Thank
All
you so
done, ma'am.
much.
I don't think that was a very effective cross. They're going to get their expert in shortly, and I will be back. Just chat. Thank you for being mindful, even if I am not on screen. And thank you for following all the rules of the chat. I will be back shortly. And we're going to let the trial roll because I know you guys love to be here with the chat. And we're going to get background training and experience on the expert. If anything wild happens, I will circle back. Don't worry. The mods and the production team will let me know. And they're also here to be with you. So I will be right back. And I think we'll be getting into the expert for the defense. When I leave, the court sound goes. Okay, give me 1 second to just
Defense ready to call your next
do
witness.
this.
Yes.
Chat, that was me. I accidentally muted myself and it took away the court sound. Don't worry, you didn't miss a thing except them bringing her in. I will be back in a bit.
President.
Yes.
We are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Judge, before we began trial, I had indicated that in the past, historically, there were problems with cameras showing attorneys' laptops. It's been brought to my attention that that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be a phone or the court TV pool camera, that they not do that.
Okay, all right. Members of the gallery, good afternoon. And the TV crews as well. Information that's contained on both parties' laptops, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you. All right, we are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Gestro on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. All could be seated. Again, members of the jury, if you could just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time you may call your next witness.
We call Dr. Julie Harper.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of positions have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly But then it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
And is that where your practice is currently?
Yes.
Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along other
Is it
cities.
fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right, and when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert, in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. And I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would, need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Ms. Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Ms. Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have it.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had a clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from Jorge Torres' records?
I did see his hospital records.
Now, do you consider, in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with...
Conduit 704.
Approach. The objection is sustained.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Pleading Conduit 704.
Sustained.
You considered the entire family background and history without going into the details of what she said or what you learned from looking at records? I'm sorry?
Yes.
And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
And testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual and your studies and your experience, where they require excessive admiration of what there's reason for it?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it, just
All
if
right.
you need to review, if you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything, and we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support?
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason.
All right, chat. We are going back live. We're switching feeds real quick because I'm back and I know you guys had some echo issues. Let me know in the chat. I know there were a few things I missed. Don't worry, we'll catch up on them when we come back. Thank you all.
And if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right, and so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Okay. Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
Oh, we're just getting into testing. Perfect.
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
All right. I'm getting my in-ears fixed.
Explain to the jury what that Miller Forensic Assessment of Symptoms test is.
Chat saying she hasn't been tendered
So
as an
that
expert
is
yet. Good
also
on
a
that.
test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be
Her mic is a bit
unusual
hot.
or not typical of a valid psychiatric patient.
I
What
missed
were
you
the
guys
results
too.
of Ms.
Oh, they did have her
Boone's
identify
test
Boone.
on the Miller
That's good.
Forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you
So
tell
they
the
did not
jury
think she was feigning or malingering.
what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder.
That's the court
It
feed.
allows
Oh, that's
me
me.
to interview
Apologies.
a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
All right, chat. Don't worry. I will catch up with what I
Did
missed.
Ms. Boone, in fact, have post-traumatic stress disorder?
Well,
Or tell me the results. Just
yes, so the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test, that wouldn't be appropriate, but it is consistent with the background and the
Rainy Day Girl in the
symptoms
chat,
that I
thank
had
you.
previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms,
I'll keep an eye
that
on
was
echo.
consistent with the outcome of that test.
And with this testing,
Ooh,
all the
that's me.
testing,
Sorry.
help you
CPS,
determine if Ms.
CPTSD
Boone
is
had a
complex
change in
PTSD.
functioning from before the alleged trauma
Bless you.
to to after the alleged trauma, and I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay.
So
But
PTSD
would that
from
testing
IPV
help
is what
to
they're saying.
determine
Okay.
if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from a trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to
No.
make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in the arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
What
Sheila
did
says in the
Ms.
chat,
Boone,
can they bring back Brian
what had she
Boone?
been
The state
diagnosed
can,
with prior to you getting involved?
in their rebuttal. The defense can.
Roach.
So they're talking about what they reviewed. So chat, as we get into this, I see a lot of questions about whether or not there are quote unquote excuses here. We are talking about court. Court is incredibly specific. So we have to remember that when we are looking at court and legal process, we are looking specifically at court and legal process. And the defendant has the right to an affirmative defense. She is putting on an affirmative self-defense defense based on battered person. So the lens that you look at a murder to, which is the charge here, through is a lens of whether or not they knew it could cause danger. But when you're looking at the lens of, oh, my necklace keeps getting caught in my in-ears. When you're looking at the lens of whether or not the self-defense was reasonable, whether a reasonable person would be in fear in that circumstance, whether a reasonable person would perceive that this is dangerous. And you'll hear people give examples like if you're confronted with a weapon, would a reasonable person think that they were in imminent danger? That's not the circumstance here because the defense is arguing of Sarah Boone's history, her trauma, and her experiences. So the defense is arguing that Sarah Boone's perception of danger is different and that needs to be considered when looking at whether a reasonable person would have perceived danger that they needed to respond to. So we are not talking about what may be morality and whether or not there is a quote unquote excuse. What we are talking about is in court, can this be a defense? And will the jury see this as an affirmative defense? So hopefully we're looking through the right lens at this, because when we talk about morality and legality, there's a lot of things that are legal that don't feel right. And the court process is an adversarial process focused on the rights of the defendants. A lot of you in the chat feel that the victim's voice is lost in this. That is a regular and persistent complaint within the criminal justice system because the victim has had what happened to them happen to them. The defendant is the one who has the constitutional rights as the government is trying to punish them or rehabilitate them for the thing that was done. So I understand how frustrating that is, but it is a part of the adversarial system.
But
This
you would
system
agree,
right
and I
now.
think this is a fair
Oh,
question.
I'm going to finish. This system right now is focused on the defendant, the defendant's rights, and what the defendant did not do, perceived, did not perceive. That is what they are looking at. So we are breaking this down into whether or not there is an affirmative defense here. And I'm not telling any of you to agree with the affirmative defense, but please keep an open mind because the defendant has a right to an affirmative defense. And our legal system is in a kind of a I don't know, silo by itself outside of like the everyday world. In the everyday world, you might not ask somebody ever if they've ever used a zipper before. Court world, we're going to have to ask somebody Well, are you a zipper expert? Which I thought was ridiculous. Everyday world, you show somebody a picture of a person and you're like, oh, that's a picture of a person. Court world, there has to be foundation and timestamps, and we have to know where it came from. So the affirmative defense doesn't mean that what happened here is okay. I don't think anyone's saying what happened here is okay. I don't think anyone's saying that it is what someone should or should not do. But what Sarah did, she did. I don't think that's controverted. What Sarah did, she did. This defense goes to why she might have done it and why she is explaining she did it, so that the jury can either acquit her. That's what the defense is going to ask for. They can either say, we don't believe that at all, and convict her of second degree, or they can convict her of manslaughter, which is going to be the lesser included. So there's lots of room in this court system that operates different than everything else. It doesn't make it okay, but people are complex humans. Humaning is hard. People are hard. And our court system is not perfect and is constantly evolving. Watch this week's episode about the Menendez brothers case. Our system is evolving. Our understanding of humans is evolving. We are all evolving. So we're trying to take the defendant as a whole person, telling the jury, this person with this experience on this day did this thing. Does that thing make sense in the context of everything? Or does that thing make crime, for lack of a better word, in context of everything? So is there self-defense here? Is there not self-defense here? And we are in the defense's case, and the defense's case is going towards self-defense. So hopefully that helps answer some of those questions as we get into listening to what this doctor continues to have to say. I'm glad I'm back. Eventually I'll be out of NDA and be able to tell you all about my meeting.
Question, you would consider prior other experts who may have diagnosed her with something?
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
I mean, which is
okay, given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records.
Thank you, DH. We're here to try to understand.
Did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder. It's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
At the time of the offense.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that
That's
disorder?
an interesting diagnosis.
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Sustained.
You have viewed
When the witness and I are making the same face at the defense attorney.
involving her being stabbed.
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
I mean, it's the side of the leg, but okay.
Overruled.
She's probably also seen pictures and medical records,
generally, without
right?
getting specific. I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Who's testifying?
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping, so their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They have
features.
trouble sleeping sometimes.
She
Yes.
said that.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
I don't know if Sarah Boone's going to like that
And alcoholism
diagnosis.
can be, depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in
Let's just ask her
diagnosing.
to explain.
Yes.
The many people who suffer from alcohol
He's annoying
use
me.
disorder, I don't know how to put this, are they in denial?
I would say that that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
StreamYard, I was not looking for Nightbot. I was looking for Aurelia. Yes, this. He needs to say little and
What
let
is
her
the
explain.
difference between traits and a diagnosis?
Oh, they must have talked about MPD, yeah?
Well, we all have personalities, and so you're going to have coping mechanisms that include personality styles. So, for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like, feelings. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like, and that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD, or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware
I
that
think the defense keeps referring to it specifically as battered woman because they are continuing to try to connect it to Sarah Boone and continuing to use that language to connect it. And I appreciate the experts constantly trying to update and use the more modern language. I think the defense is trying to keep connecting that to Boone, not to George. I think that's why they keep doing that. That's
concept,
what I think from watching that.
being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case.
Yes.
In a criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Uncovered?
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
Just briefly touch on, because I know Dr. Brannon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
It's not linear.
I think you're referring to phases that a person may go through or the cycle of the relationship. That includes the tension building phase in which there is the first instance that tension is building within the partner. There might be a change in tone.
When your expert has to guess at what you're asking, it's not great.
A signaling that there's a difference in agitation. The second is the true battering event, so something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim is getting abused, you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone, or some small behavior that might not mean much to another person, but it has preceded other violent acts. So, for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home, and that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because, again, it's specific to that dyad. Those 2 people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hyper-vigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk.
Recognition.
So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur, and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of a scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone.
Which
this,
event? Are we talking about?
23rd,
The murder.
2020
Okay.
event. Is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur?
Yes.
When a threat was about to occur?
Yes.
A threat of danger?
That's right.
Now I want to talk about placating.
He is trying to lead,
A victim
and I don't know if
placating
he
an
knows where
abuser.
he's leading to.
Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means
Is he reading from a
to
book?
delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into.
I'm just going to note that it's very interesting to me that the languaging this expert has used mirrors some of the languaging Sarah Boone used in her testimony that we did not hear in her interviews. And I wonder how much Sarah Boone grabbed from this expert and learning from this expert in their conversations, because Sarah Boone didn't say in any of her police interviews, George needed a change of scenery. Those things started after she met with this expert. Those were not present in her immediate interviews and are present now. The cues was exactly the word Sarah Boone used. She didn't say, I saw or I noticed. She said there are cues. So she has used some of the exact language from this expert, which I think is really interesting because this expert's not changing her language. She testifies regularly. She says things the way she says things. Verbal patterns I find are hard to break if you're used to saying something a certain way. So it's interesting to see the way that Sarah has mirrored some of that languaging in her testimony, but not in her interviews that she gave early on.
Abusive event, if possible, doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone.
Yes, Chad. Sarah Boone has told everyone she is a straight A student. Yes, yes.
Her words, I
hear
would
you.
say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain. sharper words come out. I think that that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brannon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So don't try.
I don't know who ran that study. Somebody, they talked about it earlier, who ran that study.
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on, and it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're
He should
numbing
just
their
ask
emotions
questions and not testify.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Do some people with this syndrome disassociate?
Relevance. Approach.
And they're going to approach regarding disassociation. I don't know if Owens knows where he's going with some of these questions. Like, the point of leading is to lead somewhere to where they're leading. open-ended questions, I think, would do better here for Owens with this expert, because he is jumping around in a way, and I know I was in a meeting for the first part of her testimony, but he's jumping around in a way that is a little bit difficult. Kelsey in the chat asked if my neck's bothering me. No, my in-ears are bothering me, and the cord goes down the back, and it's been grabbing at my hair today.
Being able to psychologically
So no, not my
detach
neck,
from their
my
body during a traumatic experience.
in-ears.
Some people do experience.
He won that objection. So no, I've been having technical difficulties.
I'm just going to list some of the
No,
symptoms that you find.
Don't
in
list the
battered
symptoms.
spouse women, and just to see if
don't
you,
list the symptoms. Don't list the symptoms. You're not testifying. This is your witness.
agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes,
The severe anxiety and hypervigilance,
yes.
the panic attacks,
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
very low self-esteem,
Yes,
poor body image,
sometimes.
feeling that they have no control,
Yes,
sexual dysfunction,
it can be, particularly if the trauma includes sexualized attacks.
short-term memory problems and confusion,
Yes, that's part of PTSD sometimes.
and they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear,
Yes,
constant fear.
that's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
He's not even asking a question. Do I have any Zoom room? Oh, we do. We have Zoom room. Owen's questioning of the expert is not as straightforward as I would like. So it's a little hard to follow. Just ask open-ended questions and let the expert testify linearly and directly. I
may
think
proceed, sir.
this is the most critical part of their case. So maybe I am being too critical. But for me, they fought for this. This is the most critical part of the defense's case. And to present it poorly, it is difficult to follow, and it's going to make it difficult for the chat to follow, or the jury to follow. The in-person chat, the IRL chat that has to vote at the end.
All right, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting,
Yes, that could be an overt act.
kicking,
Yes,
punching,
yes,
choking,
Violence can include all of these things.
yes,
using weapons to hurt you,
yes,
a knife,
correct.
curtain rod,
Yes,
threatening to hurt you, your children, or your pets,
yes,
belittling and humiliating you,
that's correct.
taking your car keys,
That would be considered a form of control, so yes,
controlling your money,
yes,
control where you go and who you see,
correct.
and who you can talk to,
That's right.
force you to have sex when you don't want to,
Yes,
stalking you,
yes,
slapping you,
correct.
Why are we doing this in the style of a cross-examination?
You agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So,
sadness,
yes,
hopelessness,
yes,
worthlessness,
correct.
intense feelings of fear,
Yes,
It's not cross-exam. Owens, Gotta let her finish. She's-
Abusers have a tendency
You're a
to have
witness.
low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself,
Yes.
have a desire for power and control,
Correct.
have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper,
That's correct.
become jealous easily,
Yes.
very possessive.
Can be.
All of the flipping leads me to believe this is not a well-organized direct examination, but the questions kind of did that already. If he's ever cross-examined an expert before, there is a pattern.
Victims can suffer from
that. The feed just jumped? That's odd. That was the feed jumping.
The victims can suffer from
That was a feed glitch. I don't know what that was.
Yes, sir.
MJJ asked, maybe Owens is a new lawyer, like a late in life career? No, he's a fairly experienced lawyer. He was the elected public defender elsewhere in Florida. So the head of the public defender's office, and was a public defender for a long time. There's no way this is his first time crossing an expert.
analysis in your diagnosis.
Yes, I did.
It's clunky.
And I'm going to show you some pictures.
I mean, he's got a lot going on, to be fair. There was a lot to manage, but this is the key of their case.
Are you familiar with that?
Yes.
Exhibit 11, are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph?
Yes.
Exhibit 9, picture of the bloody knee.
Counsel, you can just ask if she reviewed, you can show her the photos and just say, have you reviewed all of these?
Yeah.
Defense exhibits number through number.
7, picture of her, Sarah's lips and eyebrow.
Yes.
This is a composite exhibit 6, pictures of the
Lawyers of the chat, don't do this.
janitorial light. Are you familiar with those?
Yes.
Give her all the photos. Ask if she's reviewed them. That's it. That's all.
She spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn. Exhibit 4.
Yes.
Agree with that? Looks like exhibit 3. She slapped.
Yes.
Exhibit 2. Picture of bruising in his boot.
Yes.
Did you consider all those?
Megan MC in the chat asked, is this lack of preparation? It feels unprepared to me.
Today, as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times, they're very slow to open up and tell you about the abuse.
That is correct.
That's a good
They'll
question.
actually often lie about it.
deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this group?
Yes.
That's all the questions I have.
The last questions.
Any cross-examination?
Yes, sir.
Oh, yeah, there's going to be cross. The last questions I thought were helpful because Owens is going to argue the interview. Of course, she wasn't forthcoming with police. Of course, she wasn't upfront with police. That's what the argument from defense is going to be. And he's using this expert at the end of that question, because there were 3 in a row that were helpful, with the end of those questions saying, this is why she interacted with the police in this way. So that's helpful. Let's get to cross. Also, the fact that the defense was able to say 9 times without saying 9 times, like Mr. Rooney, is something my brain doesn't understand. But here we are. I mean, because murder trial, I'm being hyperbolic, but also that's how my brain hears it.
Good afternoon, Dr. Harper.
Good afternoon.
Sorry.
You've done some evaluation
I have no
work on
idea how the feed got yeeted. This has happened like 3 times this trial. The feed like self yeets. Y'all. Oh, just cue the We Are Professionals bumper. Have we played this yet today? I don't. It's new for this trial. Smurfana said it's happened to Peter too, Emily. Oh, this is a StreamYard issue then.
battered spouse syndrome for a prosecution?
Makes me twitch.
Past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains...
I'm going to back this up just a little bit, just because I am still discombobulated, and he was asking about the government hiring an expert.
That you've expressed here today and given to this group.
Yeah,
Yes.
Emily, you went too far.
Dr. Harper,
Good afternoon.
so you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days, because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get 1 crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right? Specifically when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh,
Of court appointment.
The question,
Legal objection.
objection,
Legal grounds.
he asked a question about battered spouse and
Approach.
I love this judge so much. He saw Owen's face and went, grounds. He didn't say grounds, but he went grounds. Grounds. He went legal objection. What he says by that is he wants you to say relevance, speculation. What are the grounds for the legal objection? And Owens was like, but Your Honor, he's asking questions. He's like, get the fuck up here. Get up here. You need to state the legal objection. Stop arguing in front of the jury. And this judge has that dialed.
Objection sustained.
But then it got
When it
sustained.
comes to an affirmative defense such as...
It was calling for a legal
syndrome
conclusion, I think.
Being used for self-defense or, not and, insanity.
Owens got there
requires a
eventually.
court order for the state to go have an evaluator go, right? Yes. All right. Now, What are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response, like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So a pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up
He's
and it
getting
says
to the fact that there's
9
no criteria.
and 5 of those criteria must
It's
be
not
met
diagnosable.
to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the, like the Ohio State University or something, is it written down anywhere? Can one...
I didn't think we would be talking about the Ohio State University, and I don't even know why. But you know the judge is an FSU fan. He has a giant FSU mug. But then again, this is the prosecutor that talked about vampires in his opening and talking about the fact that you have to invite them in. So I don't... what?
Psychologists or psychiatrists rely upon a recipe or a list of criteria that everyone else would be using in your field as well.
There is no standardized approach you must follow. In other words,
Christy,
sometimes
thank you.
if we have a statute, for instance,
went
would
to the
identify
Ohio
what we
State
must
University.
investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual, by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli.
I mean,
correct?
it's more on the subconscious.
I
but-
only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor
Muffins.
go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, I guess, cues for that.
I would also say that I hate this example because first responders, including law enforcement, often have trauma that they don't acknowledge because they're like, it's part of the job, and have all kinds of secondary trauma that they also don't acknowledge because they're like, it's part of the job. So they may have normalized it and have really good coping mechanisms to deal with trauma. But I don't think it's that they don't have trauma. I think it's that they have coping mechanisms to deal with the amount of trauma. So they might go to a crime scene and be like, it's a Tuesday, but that doesn't mean they are not traumatized. But he didn't get to muffins, which is why he's now getting the smoke from me on that analogy. But it's for everyone in the chat who is just like, it's my job, it doesn't mean it's not also traumatizing. So, which is why she was just explaining PTSD, where veterans might be like, it was my job. I did my job. And she's like, right, but your body is telling me you have PTSD. So it is more complex than that, but that is not his point. But I was going to say it either way because yes.
That person, and also working with law enforcement, they become seasoned to micro traumas. So the first, almost every police officer.
Well, ma'am, I adore you. I should have just kept reading. That was on me. That is completely my bad. I should have just kept reading because she's like, right, but your analogy is bad because also people being able to deal with it doesn't mean it's not traumatizing.
Officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
He's asking, so even though I take issue with counsel's analogy, I appreciate that he is now asking, just because one might have a PTSD response does not make it okay. So we're going to get into the heart really of this cross-examination and see if it lands.
Who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
He's actually asking for a legal conclusion.
But battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer, though, so I'm aware of it, but I cannot debate fine points of that with.
She just said objection calls for legal conclusion in expert witness.
You. I'm sorry.
I'm just helping. I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach.
That is getting very close
Question withdrawn. May proceed.
to calling for a legal conclusion. I'm not surprised it was withdrawn. Remember, the prosecutor was objecting when the defense was trying to get into this jury instruction and ask specifically. So I'm not surprised the defense is doing the same.
So you would agree that, hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship?
It could.
Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you
I want to know
gave it
more
to
about
them,
this bike thing.
is that a form of potential exertion of control over an intimate partner when you give somebody hypothetically a bike but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Passports.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common?
That's right.
They did not live together?
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
What?
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids,
I'm so confused.
than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband?
With phone calls, yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand?
I know you know them. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4 years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Well, you said for 24 years. That's why I was confused. You can't be 18 for 24 years. But 24 years ago, I would agree.
You
Did her work
can't?
history
Damn
kind of
it.
flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum, plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
It was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance at
I don't know if the
least where
support numbers were in
violence
evidence,
occurred
but nobody
in front of her
objected.
child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a friend.
I'm going to back that up real quick because I hadn't heard before that. I hadn't heard that before either.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Ms. Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes.
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
That's right.
And February 24th of 2020, the child was scheduled to be picked up by Ms. Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes?
Object.
Approach.
Well, I want to know the grounds of that, and I wonder if the state is working up to calling Brian Boone in their rebuttal, because I imagine that they will. We have a little zoom time, so I'm going to zoom past this.
Intentional. That
Sorry, past this sidebar.
Objection sustained.
Rephrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That,
I object.
Approach.
I zoomed. Now we're back at the bench. Someone misunderstood what the judge said, it seems.
The
Quote unquote, swore on her.
to give them any weight whatsoever. Question is struck. Okay. Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
Questions are not evidence, which is why during direct examination, there shouldn't be leading from counsel. But
She's quote unquote swore on her child's life that it was not intentional. That. Correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's unbidden.
why are you giving up? Show her where it is in the transcript.
Some of Miss Boone's diagnoses
Just go show her.
predated her relationship with Mr. Torres, correct?
yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
Well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Also, yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
I do.
In a medical record, you would use that shorthand for
Ethanol.
alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
Right.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist, so let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes.
And you can and do make diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking?
Is he going to show her the
For
bottles?
instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
If he says mega pint at any point today, I'm going to fall out of my chair.
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of
Wine glass is
2018,
very
when
in
she came
size.
in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165.
Thank you, members, for using your mega pint emoji.
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
She takes issue with your question, counsel. Are we just going to stare at each other? Oh, are we going to look for the police report? What are we doing?
So there have been two sets.
Guess we're gonna look at each other.
I believe you may have the same set that I received on September 27th, 24. Can you turn to page 21 of 57 of the Aspire records?
Oh, he's like, I'm not letting that go.
mine aren't numbered, but I will.
May I approach the witness?
Yes.
Mine aren't numbered. Talk to defense counsel. That's on them. You're their expert. Mine aren't numbered. That's on them. I appreciate, as an expert, she is not going to let any of the attorneys put words in her mouth. And so if he is mischaracterizing Boone's behavior, she is not going to let it slide. If he is correct, he is going to hammer that point home. We will see. I'm zooming because I have zoom room. I forgot I did. She's just staring at him like, what are we going to do?
All right, may I proceed?
You may.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the defense on September 27th, 2024. And just at the top, you can read the first or the fourth lines.
Judge, I would ask that she be allowed to read that entire paragraph. Under the rule of completeness,
Approach.
All right. They are going to approach over how Sarah Boone was described in the medical records in December when her blood alcohol or breath alcohol, apologies, was 0.185. I am curious to see where they're going. Y'all, are we questioning whether there's an alcohol issue? Like, at all? I'm not questioning it. I saw Kim in the chat saying, I didn't know Emily was covering this. Kim, Lauderdale. We've been talking about it since at least last week. Lauderdale. I don't think the jury's sitting there going, wait, she drinks? Shock. I don't think anyone's questioning that at this point. There is an alcohol problem here. There is a substance use problem. She has been diagnosed with alcohol use disorder.
Thank you.
All right.
You may proceed, Mr. J.
Thank you. All right. October of 2018, there was a second visit to Aspire.
Looks like he got told to move on.
And that was based upon her being found stumbling by law enforcement
nope.
with a .185, correct?
She walked up. Okay. So I'd have to say
He clarified the date.
no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you.
The part she seemed to take issue with was when police approached her.
When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask opposing party, you want me to show her prior statement before I ask her that?
I think she's got a deposition.
Do you have your transcript?
For those of you in the chat asking what's Baker Act, you might have heard it referred to as a lot of different things. It's an involuntary psychological hold like a 5150. It has nothing to do with me. It has everything to do with probably I would imagine, a statute and or a case and or both. So Aspire is a medical facility, hospital group, and a Baker Act is a involuntary hold. In California, it's a 5150. In Massachusetts, you've heard it referred to as Section 12. So it's that. So the involuntary hold or the forced hold. However,
So for the record,
whenever my youngest says I'm forcing him to do something he doesn't want to do, we're in Bantober. He's tired of Bantober at this point. I will not be surprised at some point in his life he starts calling it being Baker Act because he's forcibly being made to go to brothers' band events. So I'm waiting for that to happen with my 12-year-old. At some point it's going to happen.
it's page 34 that I'm referring to. Line 16 and 17.
I don't know who Baker acted her. I don't know if it was her ex.
Yes, I'm with you.
She described that as June of 2018.
Thank you, Michelle. Michelle in the chat said it was named after a Florida State
That's
rep.
what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside then and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate incidences. January, when she came looking for the pastor, correct?
She said June.
So I'm just clarifying that there's a record that we started with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
January 2018. Though two things can be true at once. All right, I'm going to zoom as she's flipping through the different records that they are getting into the detail of.
Referencing.
Yay, zoom, zoom.
The hospital records are not referencing her relationship with George on the January date.
She's like, the records don't say she said that.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Ms. Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
Not I didn't see inside her scalp, so I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
Her hair follicles?
Did you ask her how it was that she was injured when you was dragging down the stairs?
I don't think I went through specific injuries to her, no.
The thing that's hard is that there are
Do you agree
instances
that alcohol
that are very well
intoxication affects
supported
the credibility of a
and
historian
others that are not.
providing history to you, patient, or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
Are you talking about the criterion of narcissistic personality disorder? Yes.
Like page 761 on your hard copy?
Thank you. All right.
Was I close? I have a digital copy.
Chad, I know
760.
that there is other stuff going on in the world. As always, I see it in the chat. I see that we've gotten off topic some. We have like 25,000 people that want to watch trial. I appreciate you. You can ping me on social. You can send stuff in email. For the chat, I very much appreciate when we stay on topic. I know there's stuff. I can see it going on in other trials and elsewhere. I appreciate you guys staying on topic. It helps me as a streamer because I get distracted and I can't go running down rabbit holes. And for those that in the chat want to also try to focus, especially when we're in scientific testimony, our brains might wander even when we don't want them to. So thank you for staying on topic. I very, very much appreciate it. So we don't derail the whole chat because then the mods are going to just, just time out. So thank you for that. It's really an appreciation and a consideration to me because I can't process all of it. At once processing this is hard enough in real time. So thank you guys for understanding that request.
One of the criteria.
We'll check in with the other stuff, I promise. Just not now.
Sense of self-importance.
Wait, I want to actually, I really actually want to hear him go through narcissistic personality disorder, and I don't want to get distracted by it. So thank you. And I want to read the chat. And I can't if we're talking about other stuff. So thank you.
All right.
Was I close? I have a digital copy.
760, but
I really want to hear about NPD.
One of the criteria is has a grandiose sense of self-importance. For example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with.
Reading out loud is hard. I'm not going to give him a hard time on that.
4
I
requires
struggle.
excessive admiration.
Yes.
5 has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7, lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8, is often envious of others or believes that others are envious of him or her, correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
That's where that question came from. Arrogant or haughty.
You believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance?
There are indications that she feels like that or has expressed that before.
I hope, and I'm going to pause before we get through it, I hope the prosecutor goes through, we'll see, the things that Sarah has said that he's asking about. Is he going to go through, well, you heard in her interview, she said this, and that kind of stuff. We'll see if he goes line by line. He may not. And this may be why he didn't pin Sarah down on it, because he's going to pin the doctor on it. So he's not going to confront Sarah Boone with all of that. He's going to confront the doctor. We will see.
So that's a yes.
So yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No.
You remember going to the state attorney's office on October 1st,
I was like,
2024?
oh no.
Deposition.
I do.
It was in front of a court reporter, like Madam Court Reporter here.
Yes.
And you swore to tell the truth, the whole truth, nothing but the truth, correct? And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement?
Yes.
Is not interpersonally exploitive?
Correct. She is not.
Interesting.
And when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real-life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
Oh, interesting.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
This could be, yes.
What other traits just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left.
That was
for
the
instance.
feed video that froze, not you.
Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page.
And yes, Chad, it is not lost on me that this doctor said she is unaware when she is inconveniencing other people and has gone through 9 attorneys or 8 attorneys to this one. It does not surprise me that she is unaware that she was inconveniencing her attorneys, that does not shock, I think, anyone who has followed this case, and I have not followed it nearly as long as a lot of you.
Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
I'm surprised she didn't
Medical records
look
for
at the
Mr.
text.
Torres,
that's right.
the medical and Aspire records for Ms. Boone that we've discussed,
Yes,
the crime scene photos from the incident in February,
that's right.
pages 1 through 413 in discovery in this case,
Right.
a photograph of a suitcase and 2 videos involving the suitcase,
That's right.
and additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV?
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right, and did you review any body worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Chad, I don't
Are you
think
speaking
she
of documents
talked
only?
Yes,
about
yes,
the police
materials
interview.
other than your 9 visits. to
She
Ms. Boone.
should have reviewed the police interview, but I don't think he said that. But it might be encompassed with police reports.
Just checking with the folders I prepared for today. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No,
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No,
And you didn't review the phone text messages extracted from her device, correct?
no, I didn't.
She could have.
Did you review any records from the jail?
No.
Oh, thank you, chat, for letting me know. She said
And,
earlier she reviewed the interview. Thank you.
Yes.
All right, and they are approaching. Y'all, there is a new episode of the podcast out on the podcast feed. As a reminder, that is where I cover the other things going on in the law. So don't worry. I know there's a lot going on today. I will get to it when we're not in this trial. But today I talked a bit about Diddy because every week I talked about a bit about Diddy, talked about the Menendez brothers, and talked about what's going on in the Karen Reed case, and talked about the appeal. So that is what's in the podcast today. And then with the stuff that is going on it seems to be in the YSL case, I will, if I need to, cover it in the podcast for Monday or for next week. So do not worry. But we're locked in on this one. So there is no, we're in it, whether we want to be or not. Well, I am. You can watch multiple things at once. This is a long sidebar. Let's see. Are they almost back? No, this is a long sidebar.
Practice of forensic psychology and
There we
psychiatry.
go.
You testified earlier.
The objection is sustained in part and overruled in part.
Okay.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
She said that.
No, I did not.
or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd of 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday.
All right, now we are moving on to the thing we all want to hear them talk about.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking until about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition.
I would have to reference,
36?
it's on page 36.
Yes, ma'am.
This part he is prepared for very well. He's like, no, I've got all my questions and I've got he's got footnotes to where the reference is to prep his cross, it seems.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
I mean, is that an inconsistency? I bought a bottle of whiskey 4 weeks ago that I haven't opened yet.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
He's getting into a territory I don't know if he can go into.
His alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Oh my God.
Please silence your cell phone. You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated.
It's interesting to me that even after Sarah Boone saw the video with police and then had the ability to review it more with her attorneys and elsewhere, she still, to this expert, described herself as not intoxicated, even with all of the contradictory evidence. It's interesting to me.
At the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
Ms. TLS, I agree that Sarah Boone is in denial about her drinking.
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then they were going through them with her, and she recalled that.
I'm talking about specific.
Why can't I hear this expert all of a sudden? Did she move away from the mic while I was taking notes? Gain that up a little bit.
specifically with you, did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with
Oh,
what she
thanks,
told you
chat. She
then?
moved the mic. Well,
No,
Well, she didn't indicate to you that she forgot any part of the night, right?
right. She just didn't say that. So
it might have
Would
been
it
because I was
affect
hard to look at
your
her.
evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before videos?
not really, no, because the event and like the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours of, an itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
that's what she told me.
She said it was a good day.
Yes.
And
I'm not singing.
there comes a point in time where
Only
the
my head.
activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower,
Right.
and when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad.
On the video, he
And
sounds
that
concerned to me.
in turn made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
She doesn't remember.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important
Okay. Then explain. Why wouldn't you ask that question?
because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
be
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
Ooh, I dropped my
She
pen.
never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
It's interesting to me, and I think the prosecution's reason for pointing this out is because in all of the interviews in a safe space with somebody who is there to be kind of on Sarah's side, there to talk to her, there to listen to her, there to see what's going on, and I'm sure presented to Sarah as very much as if she was on Sarah's side. Part of her defense team, Sarah never disclosed to her what was said. I still am of the opinion, and I'm open to changing that opinion, but I am still of the opinion that Sarah does not remember. But it makes her testimony in court stand out more, that all of a sudden there are much more specifics, and those specifics weren't recorded when Sarah seems to have a history of recording what is being done with George or what George is doing and what have you. So it's interesting to me that it was not followed up on and that Sarah didn't disclose it later, but when it came to court, then it's disclosed. And that's something the prosecution will argue. And the doctor's explanation is, that is not how clinicians operate. I'm not going to confront her on that.
She was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
Oh, he's going to play the video. Maybe tell the witness you're going to play the video instead of jump scaring all of us with that freaking audio. Oh, let me turn this down a little bit. That was loud. For all of the headphone users.
You may proceed.
That's what it sounded like.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
I made it too quiet.
She described to you, Ms. Boone being the she, that she was helpful to the police?
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that
I don't like the
she was having conversations with them without counsel, I would consider that helpful to the police.
Right,
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described...
However, I also think, and he's, with this doctor is talking about Sarah's perception. I also think that Sarah perceives that she was helpful with police. Like, I think that that's true. I don't think it's what we might consider helpful, but I think Sarah thinks she was helpful, if that makes sense. And so the doctor is not going to push her on that because the doctor is more focused on Sarah's perception of the events.
Described stretching his little legs?
Yes.
And she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable.
Yes.
Correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so do we agree that that means like poking out like this as opposed to swinging it?
Just wanted him to be uncomfortable.
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
It didn't contrast to the autopsy photographs or report? did you?
Judge, I object.
Roach.
Grounds. What are the grounds for the objection? All right, we're going to zoom. I just wish he would state them so we know what they're arguing about up at sidebar. But he's asking, did you look at Sarah's self-report in context of the autopsy photos? In context of what did you look at her self-report?
Did she indicate all this nudging and
In
poking
context
with the
with?
bat was done while he was inside the suitcase?
yes.
She never told you that there was any nudging or poking with the bat when he's outside the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down.
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
And that's the end of cross.
Any redirect examination?
I'm sure there is.
Briefly, Judge.
Yes, sir.
It's 4 o'clock local time. I think this is the defense's last witness.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills.
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you.
Oh.
Can this witness be released?
That was a very short redirect.
Mr. Owens? Thank you, doctor.
Thank you.
That was a very short redirect.
Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Sorry.
I think that's
No apologies necessary.
the defense's last witness. All right, while they are packing up, I'm going to zoom and see if the defense is going to rest. And they're approaching, I imagine, to talk about scheduling.
All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible.
For the day?
Again, same instruction I've given you before.
No.
Please don't conduct any independent investigation or research as the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
The afternoon break, by the way, at 4:01 is wild. So as the jury goes out, we're going to catch up to real time here. We're a few minutes behind.
A comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13. Okay? All right, thank you. We'll be in a short recess.
All right, short recess for the court. We are live. I'm going to answer some questions. It looks like the court's going to come back in about 3 minutes. So if any of you need a break, now is probably the time. I think I actually might take a break as well and use the restroom real quick. Court should be back in about 3 minutes. And with that, I am going to put on our hold music real quick. I am going to run to the restroom. I will be 2-3 minutes, and my intention is to be back as the court is coming back on the record. I'm just going to take a very, very quick restroom break, and then we'll continue to get into Q&A and the like. So let's get our music on, and let's see. Let's do this one for now. And I will be right back, chat. Take a stretch break, get some water, use the restroom. Maybe an hour left today. Hopefully not more. Your Honor, it's been long court days. court's not back yet, but I am. So we're going to do some of our super chats and questions as we are at the court break. They were supposed to be back just a moment ago. They will probably be back shortly, but we are back and we are back. So I went and grabbed something to drink, and now we have more hydration, and it's time for some questions. So I think the defense case might almost be done, which means we're going to see what's going on tomorrow. Caitlin said, car update, car found, financing approved. Royal Blue Ford Flex. She comes home Saturday. Her name is Luna. So proud of myself. Congratulations, Caitlin. I know we've been talking about this for a little bit. We were talking about our car journeys too. So congratulations. I'm sure we can chat more about it tonight. We do have a members only live tonight, so we will get to chat a little bit more about, not this. Well, also probably this. All right. Cumulus Cloud. Emily, don't forget vampires in the opening. This case has given us some unexpected moments that I was not prepared for. This is one of them. Roy Handy said muffins equals we live in a simulation. I was not expecting it. I was not expecting another forensic psychologist to be talking about muffins. Different way, but we still talked about muffins. And then I ordered muffins and the wrong muffins arrived. So I am now mad about the muffins. Where is the muffin man? The muffin man brought me the wrong muffins, but that's okay. I will be able to go and do that myself after this trial is done, when we can go just procure our own muffins. I had a couple questions from earlier that I thought maybe I answered them that I thought I grabbed. And I am trying to look for them. Caitlin asked this, and I've seen a couple others in the chat ask as well. What's your opinion of the quality of the lawyering happening during this trial? Trials are dynamic. I think we've seen some really good questioning. I think we've seen some tough moments. I think we've seen some really good legal arguments. And I think we've seen other legal arguments that I'm like, well, you're trying. But overall, there have been, as I said, tough moments. And the court is coming back to call everything on the record. I think there's been tough moments. I also am trying to be mindful of the fact that the defense is scrambling based on the short notice they took the case. They chose that, but it's also the reality of time. So I think there have been good things and bad things, but overall, they have been mostly organized. Things have run pretty smoothly. The witnesses have been organized. So they've done a lot on short time, and that is helpful, I think. All right, let's get back to court. We're
back on the record, case number 2020,
overall,
CF 2603.
I've been madder at other cases.
Sarah Boone. Appearances for the state.
Dave Castro on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone.
Kevin Beck, Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Probably.
Yes.
Yes, sir.
So the defense is at the end of their case.
Yes, sir.
Yes. Judge, there's
I think Mr. Henderson was confused that the judge's head was down taking notes, but the judge is ready for you, sir.
2 orders that I'm going to be requesting the court to take judicial notice of under 90.202 sub 6, and they're orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my position.
Understood. Okay. You can bring them on up.
Defense is asking for judicial notice of no contact orders.
Thank you, sir.
The state has not seen
Court
them.
has been provided.
I mean, the state probably had access to them, I would imagine, if they were in the same jurisdiction. The court has not seen them, and they're like, doesn't change our position.
No contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. both cases styled State of Florida
So
versus
same
Torres
date, 2 cases.
George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of redirect of Dr. Harper, saying
barely hear him.
an element of control, and control is talked about greatly by the state when I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this Boone. These show that there were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we
He can't
rely
open his own
upon
door.
in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It's just that doesn't mean that the paperwork comes in as evidence. So that's our objection, is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part.
That's for authenticity.
And it's not hearsay. It's an order of the court. We're in a case where we've gotten in.
It might not be hearsay, but it might contain hearsay. And also, I'm sorry for all the background noise. I've got this gained up because I cannot hear this attorney well, and he is standing up away from the microphone.
Evidence of past domestic abuse. There was evidence of it, started with the state, about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. It's certainly being offered for the truth of the matter asserted. No contact order.
Bing.
Judge, that's why we have the thing that the court could take judicial notice of.
No. Judicial notice does not get you around the hearsay rules. Judicial notice gets you around it being authenticated by somebody from the court coming in and saying, this is in fact a court record made in the regular and ordinary course of business. It does not get you around the fact that there is hearsay within the document. It just authenticates the document. That's what the prosecutor said. And that's why the court is saying, yes, and.
Certain things that
But the case law says you can't utilize judicial notice to get around hearsay.
He's paused.
I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 Southern 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay.
Judges prepared.
So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
Judge is prepared. He's like, the treatise says. The treatise says. Did he just look to the other? And what was interesting that the state brought up is that this is a pre-trial, pre-hearing no contact order or stay away order or protective order. Counsel got to phone a friend. Chad is saying phone a friend the exact same time I'm saying phone a friend. Chat, you guys are bae.
Judge,
Yes.
I'll start this way first.
I'll start this way first. So he's going to get into hearsays. Hold on. I got to get my rules. I mean, mine are federal, but it's going to be close enough. Where is my other evidence treatise? Okay, we might get to the rules. Here's what the defense is asking for. The defense is asking the judge to take judicial notice, which means the judge is noticing that the thing is authentic and real. It's a court document. They are asking the court to take judicial notice of a no contact order in two different cases before trial, so before hearing, that were no contact orders, presumably between the victim and the defendant. They said they were for the name Jorge Torres. They wouldn't be relevant at all if they weren't for the victim, and the prosecution didn't argue that. So they are saying the court needs to take judicial notice of these no contact orders. The expert brought them up. The prosecution said, okay, but they're not relevant. They can be relied on by the expert, but it doesn't make them evidence in the case. You can't give the document to the jury and say, here, jury, this is evidence in the case that you must consider. So the defense has said, but you can take judicial notice of it. And the court said, but it's still hearsay. There's still statements being made and offered for the truth. And we don't have the person speaking here in court. So just what's in this document is not going to be sufficient. So now they are trying to argue it because the judge is like, well, right, but law, and then cited all of it because he is eminently well prepared. And now we're here. So the defense is starting with, let me say it this way, which means there's not going to be a hearsay exception to this.
To the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business,
it's foundation.
Then someone can come in and lay the foundational things for the business record exception.
But that's foundation.
However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order, it's certified.
But there's statements in it.
It's an exception to the hearsay rule. Also, I think the probative value of this.
Why are you arguing relevancy?
Outweighs any prejudicial effect.
Any other argument?
No, Your Honor.
Any other argument, State?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body-worn cameras, Mr. Torres is like, well, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much.
I dropped my
State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, citing 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235, at pinpoint 253, by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order. And the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Business records is just not going to get them there. Business records allows for, there are some exceptions in hearsay.
Judge, we do have the clerk of court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe.
Don't assume.
Sent some message to us back before the hurricane about what they were to come, and we said to be continued. So we haven't gotten back up with them yet. So it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay.
But we
It doesn't
haven't followed back up with them.
get you around some of the hearsay, though.
Sure.
Late.
I'll give you an opportunity to do that.
You can call it out of order.
And send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner. It's probably going to take me a little bit to find.
I'll give you that opportunity. Absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. 3rd floor?
If you subpoena to the right place.
Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take to do that, but we could present that in the morning and then rest in the morning, and then they could.
All right, that works for me.
Okay.
I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I just don't understand the relevance.
The prosecutor's like, do not make the clerk's office fucking mad at me. The prosecutor's like, no. We're not dragging someone from the clerk's office that I have to work with regularly up here for this, because the employee from the clerk's office is going to sit there and stare at the prosecutor and be like, are you fucking kidding me? He's saying, I'm not challenging the authenticity of the document. It's a court record. It's a court record. I'm challenging the hearsay, and we're going to get into that. But no, what you don't want is to get at odds with the clerk's office. No, never, ever, ever, like ever, ever.
Coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
I won't object to them coming in. But
He's withdrawing his
it's a
objection.
slippery slope for other records.
Yes, it is.
See what we do as well.
Okay. All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
But I don't want to make the clerk come in.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang-up for the court and the defendant is that they believe a clerk of the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Just have them certify it.
Then based on the court, on the concession.
Just get it fucking certified. Go to the 4th floor and get a certified copy.
By the defense, or I'm sorry, by the state, excuse me. Do you have any other objections with regard to these two non-contact orders?
Hearsay.
Mr. J?
No more objections.
Okay. For the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll identify them, please?
The state doesn't want to piss off the clerk's office. The defense could have argued public records. They didn't. They argued business records. And what the prosecution was saying is if it's certified, then it becomes a certified record of a thing happened on a day. But the state realized the defense wasn't going to make those arguments and then, called their own bluff. It should be certified. I would still make the defense go up and get it certified. I would still make them go up and certify it. But what he's trying to get to is public records, not business records. And public records are going to allow that, a thing happened in court. And that's the source of the record, and the record exists. But I don't know what's in the thing, so I can't see if there's any other statements in the thing. And when the prosecution was like, I'm not going to make some poor clerk come in here, and the judge is like, nobody's made that argument, so. I mean, the stayaways were ordered.
No contact order in
They were ordered.
2019 MM 5062, dated June 16, 2019, has been pre-marked as AB. And the no contact order in 19 MM 5114, dated June 19th, 2019, is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have.
Why don't you let the... okay, never mind.
You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the defendant. But we do need some time with her.
Okay. All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it will take on their part. And then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you
Really?
anticipate your cross being? And ballpark it again.
30 minutes? 30 minutes for your rebuttal expert? Really? Okay.
Won't hold you to it.
If his direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction. And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it.
Oh, the text
All right.
messages are all coming
Okay,
in.
so that's going to take us in tomorrow afternoon.
Closing
Are
Friday.
we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
Yeah.
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction about our spouse that we're going to be requesting.
Okay.
There'll be some there's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states.
They're talking about the self-defense
They've used
instruction.
different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, and whether or not. You want to
Does Florida
consider
have a
the
special
local
instruction on
courts,
battered
the
spouse?
Palm Beach County case that I mentioned before with Dr. Brannon, there was a special instruction in that case. And then we've got some from other states. I don't
It sounds
know
like they
what the
might.
position's gonna be on that, so we may,
Has a draft of that been circulated yet?
not to the court.
Okay, all right. All right, so here's what we're going to do. Okay, let's just see
He's like kids.
how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions,
Yup.
especially due to the complicated nature of 3.6F.
Yep.
With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay, all right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements filed October 22, 2024.
We went over this yesterday.
The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state state, have I read that correctly?
You continue to read that correctly.
And defense, you have no objection.
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Oh. Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, state, we need to address?
Thank you, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
All right. My kiddo just came in and said that he was home. The jury's coming in, then the jury's going out, and then we are done for this day. This case has been moving. I mean, there were some pauses and hiccups, but all in all, it's run pretty smoothly, given all the road bumps it's hit trying to get to here, and has moved much faster than I anticipated. The amount of arguing, like legal arguing about things, mostly happened before the trial got to court, and that really does help the trial run much more smoothly, and we've seen that here. It's moved quickly. So the jury will have this case, it sounds like, if all goes according to timing, the jury's going to have this case Friday early in the day. So I am very interested to see how the jury instructions shake out. That's one of the most important parts of a case. And I'm interested to see what the state brings in rebuttal tomorrow. So the judge is going to tell the jury to go. I will stay on for the conference, the charging conference for the jury instructions. I think it's incredibly important. So we will see. Susie Q said, do I have a prediction? No, we're not done yet. I want to see what happens.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
Thank you. Y'all can be seated. Members of the jury, good late afternoon, early evening, I think. Again, could you just raise those hands,
Like
confirm you complied with the court's
5:45.
instructions? All right, record
No,
reflect all
4:45
hands
was
have been
done.
raised.
4:45.
Members of the jury, it's 4:43. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue.
That's not Apple Standard Time. Oh, I'm behind time. All right, that's me. I didn't realize we had Zoom room. My bad.
Continue with evidence and testimony presentation by the defense, and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again, but I just have to keep reminding you.
I like this judge.
Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Or the internet. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, again, I
think
thank
they
you
count
for
as
your
a chat room
time,
in
your
this.
sacrifice, and your attentiveness in this matter, and we'll see you tomorrow morning at 9 a.m.
All right, jury out. Jury out for this day anyway.
You all can be seated. Thank you. Anything else we need to discuss, State, before we go into recess for the evening? Defense, anything else?
No, sir.
All right, we'll see you all tomorrow morning at 9 a.m. Thank you very much. Court's off the record.
All right, jury out, court out, and we are at the end of day 4 of evidence in this case. So I'm going to try to do a quick summary the best I can, and then I will review some of the stuff I missed while I was on a meeting before tomorrow and include that tomorrow with my thoughts, but I'm going to review that later tonight. I've got some appointments before we've got the members only, so it is still a busy Wednesday here. Remember, the podcast is live on the channel as a VOD or in any of your favorite podcasting apps. In the podcasting apps, it will be The Emily Show. that's where you can find it. If you are in the Law Nerd app at lawnerd.com, you can find all of those. We update when we drop videos, when we're going live. We remind you of members only live and all of the rest of it. I'm going to try to summarize. It was a busy day. My head is, I'm yacht rocked. I went to concerts and my brain is like, we did a lot today. This trial is moving quick. But if I feel that way, do you feel that way? Do you think the jury feels that way? Do you think they feel like we've taken in a lot, like it's a lot of information over some really long days, which is why I'm a big fan of juries getting to use notebooks so they can at least kind of take notes of the things that they find important, because it's so much, like, we don't normally take in this much information in a day like this, and that can be very difficult for anyone to process. It is a lot to process. Let's try to do a quick summary of today. At the end of day 4 of Florida versus Sarah Boone, Sarah Boone's defense team is just about to rest their case. It looks like one last thing that they want to do is have the court take judicial notice of 2 stay-away orders or no contact orders issued to Jorge Torres in 2019. There were 2 misdemeanor cases, and those orders were issued at the same time. There was some fighting on the record about it, and at the end of the day, the government acquiesced, even though they had objected, and it looked like the court was going to grant that objection, but it was going to come back around another way anyway, so they acquiesced because it's going to come up, it seems, on the body cam footage that the state is going to play tomorrow in day 5 of trial when they get into the rebuttal case. The state said that they've got about 2 hours of video from both the body cam of officers who responded to incidents with Sarah Boone and Jorge Torres, and they've got other video from the phone that they want to show. I'm interested to see what that is. The state also said they will be spending at least an hour going through text messages. They made no mention of calling Brian Boone back to the stand. We will see if they do or if they don't. But the text messages on the phone, I am interested to see what they are going to be highlighting for the jury as they get to the end of it. And then it looks like we will be getting to closing arguments on Friday after they decide jury instructions late in the day on Thursday. And then the jury will have this case to deliberate. They will be deliberating on second-degree murder. They will be getting self-defense instructions. I think the charging conversation over those jury instructions is going to focus mostly on that self-defense instruction, how that self-defense instruction will be given, and what it will say, because that is critical to the defense case. Then we will probably see the lesser included of manslaughter, unless the defense argues against it, which I can't imagine they will, because they argued essentially that the second degree should be dismissed when they argued for a judgment of acquittal. And they argued we should allow the manslaughter to go forward, the lesser included, but not the second degree murder. So I think they will be looking for that manslaughter instruction as well as a lesser included crime. No, she's not charged with both. Yes, she's just charged with second degree murder, but the lesser included crime can be given at the time that the jury is charged and sent back to deliberate. And I think that's what's going to happen. For the defense today, they brought in 2 doctors, one who did evaluate Sarah Boone, one who did not, who was more of just a foundational expert to lay the ground for what is battered spouse, where does that fall, what does that look like, and explain that to the jury. We also saw a lot of the law enforcement officers that responded to instances or incidents between Sarah Boone and Jorge Torres at their apartment. So with all of that, we're almost done with this trial. I don't think the jury will be out that long, but we'll have to see. I'm interested to see how the jury instructions come in, and I'm very interested to see what else comes in the rebuttal case. So keeping an open mind, what's going to happen in the government's rebuttal? What other videos will they show, and what else will be shown? It seemed from today, the state saved most of their cross-examination of Sarah Boone for cross-examination of Sarah Boone's expert, and really started dialing into the expert on things that I would have thought they would have crossed Sarah Boone on, including, well, she said this, but then she said this, and then she said this. So maybe that was the strategy, to go after the expert who was talking about Sarah Boone's statements to her about the case, versus going round and round and round and round and round with Sarah Boone on the stand. So with that, let's get to your questions, Law Nerds. So we have lots of super chats. I know I'm not going to be able to get all of them, but Jenny said joining with no voice due to concert last night too. Breaking Benjamin, Stained, and Daughtry. So good. That does sound like a really good lineup. Worth the late night and little sleep. I mean, I can definitely tell the little sleep for me is the thing that gets me like the most. Danny, thank you for the gifted memberships. It's very much appreciated. To everyone who gifted memberships, thank you. Triple SB also gifted memberships. I saw a question. Where did it go? I had grabbed, let me grab it from Ann Bell saying, have we named the pickle yet? I think the pickle just gets named Muffin. I think we just start calling the pickle Muffin. I think that's the name of the pickle for this case is Muffin, because who knew that was going to happen? Accidental Jurist said, so she was mad, not scared. And yes, Sarah Boone relayed to her expert and to law enforcement that George said something that made her mad. Not scared, not terrified, mad. So we will see how much the prosecution picks that apart in closing. What, if any, highlight will be brought to that. Casey Cat said members only tonight, especially you new law nerds. It's great fun. We will see you tonight, new law nerds. And I will ping you, I think 7:30 Central. We should be able to make that in time. So that's the goal. So somebody said fractious. Terry Burrell in the chat said fractious muffin. I don't know if I'll remember to say it every time. Stephanie Hall said, what do you imagine the jury is thinking? I think the jury's head is probably spinning at this point. I think the jury's probably like, that was a lot of information and late nights. And there, if it were, I don't know, how are you guys feeling? If you know nothing about this case coming in, I think you're thinking, what else is there? What more do we need? What more is there going to be? The judge tells them to keep an open mind in the opening instructions. That's what I am trying to do as well. Just what else are we going to see? What else is going to come in? What don't we know yet? Tiffany says it feels like he wants to ask for more time and he's afraid to. I don't know. Vicky Thomas said, is that a big deal for the defense? Having the orders coming in, is that a big deal for the defense? I don't think it's that big of a deal because it's going to come in on the body cams and it's been mentioned quite a lot. It's not going to be a surprise to the jury that it exists, right? Nobody's saying it doesn't exist. So the jury, I don't know how much it will mean to them. The jury's going to be like, okay, that exists. Okay, that exists. Jury does not know the Sarah we've seen for 4 years. No, they don't. They have not, and they should not. They're going to see this case presented, and that is it. Richard said the judge has been waiting for years to get rid of this case, and it's so close he can taste it. And he's been very mindful of keeping everything moving forward, I think, conscientiously. So Lisa said the J is over it says a lot. The prosecutor was just like, I don't want to make the clerk come in here. Can we just move it along? Though, again, there are some fights not worth fighting in court, and fighting over a government document that can be certified. I would have said make them certify it, but that can be certified and can come in when it's been mentioned multiple times is really not the battle to fight in this. I want to see them fight the jury instructions. I think that will be a very interesting fight. So let's see. Rune said he is not diagnosing Sarah Boone. He is describing Sarah Boone. I think the jury might take some of that away too. So it is helpful. Let's see. Owens is going to ask to meet with his expert since he didn't get a chance at lunch. He didn't take as much time to do that as I thought that he might. Chat, it has been a long 7 hours of streaming. I am going to wrap because we are going to do our members only tonight. Wendy Darling asked a question about the victim's family. Do we know if any of the family is in court? I don't know. I wonder their thoughts on villainizing him. Will there be a victim impact? If there is a conviction and sentencing, then there can be a victim impact statement. I don't know if there will be, but there can be if that happens. And hopefully, if they have wanted to work with victim witness assistance, they have been talked through what the process looks like and what the court adversarial process will look like. And they will hopefully have an understanding. It doesn't I think, mitigate the frustration. I don't think it dampens how hard that is, but I hope that they were kept well in the loop and felt like they were kept well in the loop with that, because it is a hard process. And for that reason, a lot of times family members choose not to be in court for the trial. And sometimes they want to be in court for the trial because they want to know everything that is said and everything that happens. It just varies depending on the family member, the case, and how long it's been. It's been 4 years. They might, after 4 years, not want to keep reliving this. So it really just depends on them. Humans are dynamic and healing is dynamic, and court might not help. Also, with court being streamed, being able to watch it in the comfort of your own space without strangers looking at you might be very, very helpful. Very helpful, I would think. So with all of that, Law Nerds, I know we didn't get to all of the super chats. Thank you. I don't have any meetings tomorrow. So we will be in court. We will see what happens. Let's see. They said they're coming back at 9. I will probably set stream for 8:30. If court does not go back on the record at time, we might push it back 15 minutes. Just keep an eye on the time and we'll let you know in the app. But that is the plan for tomorrow. Thank you for being here. Thank you for being a Law Nerd. Thank you for riding with me for trial. I think our last of 2024, truthfully. And Law Nerds, cheers. I'll see you tomorrow for day 5.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.